Yes. Hello, my beautiful friends. What an amazing day it is. Supreme Court decisions are upon us. And today is going to be a big one. We've got 8 decisions left. We've got just a couple of days left here in June. And so the Supreme Court is coming to the close. We will get probably a decent amount of cases today, and then we'll see when they schedule the next decision day. We've got a couple that are overlapping decisions in terms of the content of what we expect to be inside. We've got 2 related to executive power and whether the president can actually fire people. We've got 2 related to men and women's sports and vice versa. And then we've got another handful with some very big ones, including birthright citizenship. So we'll see if that one drops today. But we also had some orders earlier that dropped before we get into the decisions, which are coming in about 14 minutes from now. We also had some orders, and a big one has dropped. In other words, the Supreme Court will hear a case in the Arizona battle over citizenship when it comes to voting. So in the next term, when we come back next year, when they come back in session, they're going to close out the term in just a few days. We'll come back in October, and we'll hear at some point RNC versus Mi Familia Vota. So the new orders dropped today. The petition for writ of certiorari granted. And that's good news because we want to validate that capability. And SCOTUS wire sharing, the Supreme Court will decide whether Arizona can require proof of citizenship from some voter registration applicants and remove suspected non-citizens from its voter rolls within 90 days of a federal election. And so that just dropped fresh out of the oven this morning. A couple of other cases also granted. PepsiCo, WBI Energy, international partners, someone suing Todd Blanche. Some other ones are making their way through. But what's so curious about this one is the guy called Mark Elias, who we know very well here, is not happy about it. He said, breaking! The Supreme Court agreed on Monday to hear Republican arguments in defense of Arizona laws that, according to him, are not validating citizenship. No. It's risking disenfranchising eligible voters and trying to make it harder to register. Oh, so that's their framing on this. On, of course, one hand, we've got election integrity on one side of the argument. On the other side, they talk about voter enfranchisement, and they want everybody to vote no matter what. If you make it even a little tiny bit hard to validate to make sure the election has integrity in it, they get really mad about that. And so he's upset about it, which means we're happy about it. And so some good news on that one. Now, there are some questions about whether or not we'll be done in June. Normally, the Supreme Court gets all their action done by the end of this month, but it's now the 29th, and we've got just a couple days left. So here's an FAQ from SCOTUS blog. When will the last day be? Answer: we don't know what the last day of the term will be. The justices normally try to issue all of their decisions by the end of June, but in 2024, the term's final opinions came out in early July. So we may squeak into July. Time will tell. And we're waiting for this all to drop today. And we've got a little summary here of what is left on the docket. So some big ones, and I think this one will be interesting. We may get this one today. Chatrie versus United States. And we've got this document linked up in the description, wherever you're watching this. So you can go and click this Google Doc. And when the decisions drop, I'll also drop the opinions in this Google Doc. So if you want to get the full PDF, we'll just copy and paste it and throw it in here. That way you have it. But this is going to be an interesting one. It's about GeoFrence warrants and whether or not when law enforcement is investigating a crime, can they go and just gobble up location data of all the cell phones in a particular area? And I think they did a lot of this back during January 6th, for example. They just scoured the cell phone records and then were kind of reverse engineering who was inside this geofence. And this was curious because they kind of missed the pipe bomber for a long time until they found the pipe bomber. But the question is that a violation of your Fourth Amendment? You've got a right to privacy. You've got this concept that they need to get a search warrant before they come in and get your interest, your privacy, what's going on in your house, what's going on in your car, what's going on in your cell phone? Does more public location data from your cell phone fall within that concept? That's going to be Chatrie versus United States. We'll see if that one comes down. We've also got Little versus Hellcox, and this one's kind of paired with this one down here, which is West Virginia versus BPG. We're going to have, I think, maybe both of these drop together. Last week on Thursday, we saw that they dropped 2 immigration cases back to back. We had the TPS case. We also had that combined with the border metering case, and whether coming to the United States means you are in the United States for asylum purposes. And those got paired together. We'll see if they do that on this one. So one of the trans cases is this one coming up out of the Ninth Circuit out of Ohio. Question: whether state laws that categorically bar the T's from participating on female sports teams, whether that violates the Equal Protection Clause. So it's a state law. And we saw last week that Clarence Thomas was saying there actually is no Equal Protection Clause in the Fifth Amendment, but this would implicate the 14th Amendment, which does have it. So would this be an equal protection claim? So in other words, men who transition into so-called women, can they ultimately play in these sports? And if you prohibit them from doing that, is that violating their constitutional rights? That's he-cox, which is perfect. He-cox for a trans case, perfect. Then we've got BPJ, similar issue. This one's coming out of West Virginia. This one's bringing the same type of claim under Title IX in equal protection. Question: can you allow a state to define an athletic team and the participation on that team strictly by biological sex at birth, barring the T's from the female sports? BPJ. So that one will be coming up. Maybe we'll get both of those today in the T cases. Then we've got another question about elections. And of course, we know that money has been articulated to be a component of free speech. You can use your money to do things. And so we have a lot of money being spent in our elections. Another case coming up out of the Sixth Circuit. Can there be caps on political expenditures between a political party and its candidates? Or does that violate the First Amendment? Can you cap the amount of money that you're spending? The name of that case: National Republican Senatorial Committee versus the FEC. Maybe we'll get that one today. The big one is Trump versus Barbara, birthright citizenship. And I don't know if we're going to get this one today, but it's going to be a big one. And I'm nervous about it, but hopefully it comes our way. I think there are a couple of different mechanisms that they can use to bifurcate the decision. They could perhaps latch on the residency requirement in which they reside in the 14th Amendment, a key term of phrase. A lot of people spending a lot of time on subject to the jurisdiction thereof. What does jurisdiction mean? Geographic jurisdiction. If you're inside this location, the law applies to you. Or is it about allegiance? Is it about you are subjecting yourself to the jurisdiction of the sovereign? You are agreeing to acquiesce to its laws and to agree to follow those laws. And if that's the interpretation, which I think is right, then if you come in illegally, you're flagrantly violating those laws. You're overriding the jurisdiction. You're saying, I'm not subject to the jurisdiction thereof. I am essentially challenging the sovereign. And why would you get a benefit of that illegality in the term of being able to drop a baby out and then have that baby become a citizen? Now, simultaneously, the other half of another clause in this birthright citizenship clause is about residency. So in which you reside. What if you reside in the nation like Wong Kim Ark did, whether that's legal or not? In Wong Kim Ark, the prior precedent, they were lawful residents, lawful permanent residents from China, Chinese nationals. They dropped a baby out. That baby was a citizen. But that was lawful residency. So I would even argue under that, people who are here illegally, who got a mortgage or whatever, and they are now residing here, still say that they're not allegiant. They're still kind of residing in a gray area, so it shouldn't apply to them. But if they do hang their hat on the residency requirement, then maybe perhaps the birth tourism situation can get destroyed and obliterated, because those people clearly are not residing here. Have your baby in Miami is a literal business that exists in Florida that says just, oh, come on over here, be here for 5 minutes, drop that baby here, boom, you got a new Chinese citizen baby, and you go right back to China. So Trump versus Barbara, we'll see what happens on that one today. Gives me the little butterflies thinking about that one as soon as that one drops, so we'll see. Then we've got these other companion cases, Trump versus Cook, Trump versus Slaughter. Both of these are related to executive power and whether or not the president is actually the president. We know we've got this disgusting development in America where we have Congress create kind of these pseudo executive entities. It's like an executive branch entity like the FTC or the Federal Reserve, but they really don't give the power to the president because they say, well, you got to appoint an independent commission and then we get to appoint people. The president appoints people. And it's like kind of a big mess because nobody has authority really over it. The president doesn't have the ability to just fire somebody, which means it's not really under the executive branch at all. And as our Constitution articulates, the power of the executive branch resides in a president, not in a body that gets to say, well, we like this person. And in our read, it's just perpetuating this deep state concept where we've got all these unfettered bureaucracies and more. So Trump versus Cook. Then we've got Watson versus the RNC, which is about election days and whether you can continue to count ballots 5 days after an election, like they tried to do in Mississippi/Alabama, I believe, coming from one of those cases down there. So is it an election day or not? Can we just have elections that continue for months, days, years, whatever? And we're getting close to getting some decisions. Amy Howe just emerged moments ago. She said 2 boxes today. So these are literally the physical boxes that they bring out that are filled with all of the paperwork. And that's kind of light, right? That can be kind of light. We're wondering sometimes, you know, are they hauling out like a wheelbarrow full of boxes or what? So box count at 2. I think, what did we have last time? Did we have 3 last week? We had 4 decisions last week. So let me just start making notes of that. So 2 boxes over here, which is interesting because I think on the one day we got 3 decisions in 2 boxes the last time. And then maybe we had 3 boxes last week. Someone has to refresh my recollection on that one. But now we are counting down. We've just got minutes until this all drops. You can see Amy Howe is over there. She is in and out of the courtroom. This is over on SCOTUS blog. And we'll see what comes next. I think we had 3 boxes, right? 3 last week. Thank you for the clarity on that. And we had, so with 3 boxes, we think we had 4 decisions last week, and the time before that, I think we had 2 boxes and 3 decisions. So we might get 3 decisions here today. We'll see. Or was it 5 and 2? I know, it's hard to remember. That's why we got to write it down. So a couple of, we're all recalling it a little bit differently, but 5 decisions and 2 boxes last week, says someone else. So it was 2 last week. All right. Well, that's interesting because we had 4 decisions last week, right? We had the 2 immigration cases. We had the Hawaii gun case, which was good. The vampire gun case. And then we had the Monsanto case as well. So lots of activity over there on SCOTUS blog, lots of activity in our chat. Great to see you, my friends. Thank you for joining us on these days. It's like, woo, got those butterflies floating about. So Amy Howe said, headed in to wait for the first opinion now. Chief Justice John Roberts only has 3 opinions this term. So I would imagine we'd hear from him today. And some people are saying that, you know, probably a good prediction that he's going to drop birthright citizenship. And we don't know if that's going to be a good thing based on what he did the last time that he wrote a very important decision as it related to Obamacare, when John Roberts came down and he said that it was a tax. And we all said, John. So you can force us to buy a product in America and you can just reconstitute that as a tax. And John Roberts, I don't think he's as much of an originalist or a textualist as the other conservative judges. He's a conservative judge, but not in the same vein. I think he's more of an institutionalist. He's trying to make sure that the court as an institution continues to have credibility. As we talk a lot about here, the court doesn't have a lot of power other than people's faith in the court. Other branches of government, Trump runs the DOJ, Trump runs the FBI, Trump runs the CIA, and all these and all of these other entities. Congress has the power of the purse. They can legislate, they can issue subpoenas, they can form committees and all these things. Supreme Court doesn't have a lot of that. So they've got some powers of legitimacy and credibility. And so I think John Roberts is tries to balance that, kind of tiptoe around that. He as an institutionalist, he wants the Supreme Court to to not be angering large swaths of the country. Ooh, we got an election case. First case is Watson versus RNC by Amy Coney Barrett. And Watson versus RNC is going to be the election day case. And that's interesting because Amy Coney Barrett had a lot to say about that back during those oral arguments. So first decision, Watson versus RNC, one of the clearest writers on the court today. We've got the decision queued up right here. Let's see if we can see what the split is on this. We've got Amy Coney Barrett. And wow. Alito dissenting. Thomas Gorsuch dissenting. Wow. So Amy Coney Barrett with the opinion. Roberts. Whoa, this is interesting. All right. So this is Alito, Thomas, Gorsuch, and Kavanaugh joining. So this is a 5-4 decision, and the libs are in the majority. So Amy Coney Barrett, Roberts, Sotomayor, Kagan, and Jackson. Uh-oh. That doesn't sound good. Yeah, that is a surprise. 5-4 is what we're seeing on that. Alito in the dissent. I don't know that that's any good. Yeah, that's not good from what we can see. But, okay, we've got this decision. We'll come back on it. Let's, as always, wait for the other cases to drop. But let me just see if I can just tease out a holding here for us. Held. The federal election statutes do not prevent Mississippi from counting ballots postmarked by Election Day, but received up to 5 days thereafter. Nothing in the federal statutes requires ballots to be received by Election Day. We got blown out. What the hell? So you can vote as long as you want. That's a loss. Nothing in the statutes requires ballots to be received by Election Day. What the hell? So we have election season. Election season. Wow. What a joke. So as long as they're postmarked, and by the way, this postmark crap's all just a red herring, okay? Large portions of mail are not actually postmarked, and postmarks are all super wishy-washy, and you are trusting certain entities to do all of that. So it doesn't have to be received by that time. Crazy. All right, so 5-4, you can just count ballots as they're coming in. Way after the fact, nothing requires it to be in time. Wow. What a joke. So that's not any good. 5-4. And of course, the libs are on that team because that's what they love. Just like what we saw in California. Just keep counting and counting and counting. Get the ballots in. Oh, it's postmarked. Somebody stamps it. And it comes in. And we've seen studies. There's a large portion of mail that is not even postmarked at all. Mail-in balloting is such a scam. This whole thing is ridiculous. All right, so that one dropped. And Amy and John Roberts joining with the left. Shame, shame, shame. Wow. Yeah, some people over there saying it's a surprise. Congress can change the rule. They don't care. They're not interested in actually fixing elections. They want it to be a total free-for-all. So why wouldn't every state just continue to say, hey, take your ballots and just count them whenever you want? Make it 14 days. Make it 15 days. Make it 2 weeks. Make it 3 months. Make it whatever until you win. So, yeah, Alito's going to obliterate this. Alito was very upset about that during the oral argument. And I thought most of the court was in agreement with his position, but not apparently. So great job. Once again, John Roberts and Amy Coney Barrett, which means, maybe they're having one right now. So that just dropped. And we've covered this before here on the channel, talking about election litigation and even, I think, leading into the oral argument on this case, that the postmark thing is not concrete. It's very dynamic. And then you had questions, I think, also about being able to collect those ballots. So what if somebody is just collecting the ballots, right? There's a harvester. Somebody's going around and saying, I'm going to help you collect all these ballots. And they go in and they say, I collected these ballots on this day. Who can validate that? Can anybody actually validate that? Then they drop them off maybe a couple days after the election. No, I picked it up on this day. I filled it out. I picked it up on this day. Then I dropped it off. Election +3. Drop those off. And they all count. And that came up during the oral argument. And I think we'll hear that from Alito. So we'll come back on that one. Let's see what else we get today. But not good. We should have election day. We should really have very limited mail-in ballots, as far as I'm concerned. You should have almost none. You should have exceptions for those who, have some disabilities, or those who have mobility problems that are validated by a doctor, as far as I'm concerned. But otherwise, we should encourage people to vote. Okay, if you can't get off your ass and get out there and go vote and go cast your ballot, and I've mailed in ballots before too, but if you can't do it, we should incentivize that. Then, there should be a little bit of friction in the system. It shouldn't just be universal mail-in balloting. All these ballots are floating around. The lists are completely perverted. Nothing is actually being monitored or maintained. We've got dead people on the list, people who've moved on the list. You've got duplicate people on the list, felons on the list, illegal aliens on the list. No one checks. So then everybody gets ballots, and there are extra dollars in terms of votes that are out there just floating around. So now you can just collect those and say that as long as they come in, and again, why wouldn't the states just say, okay, we're all going to do 5 days now? It's so ridiculous. Now all the states can just wait. So in Alabama, which is where I believe this one came from, or was it Mississippi? I think it was Mississippi. Yeah, there it is, Mississippi. So in Mississippi, we're not going to get results until 5 days after the election, because ballots are still trickling in. Unless you can say, well, it's overwhelming, right? Unless whatever the margin is, then you can say, okay, CNN calls it, Fox News calls it, because whatever's still coming in is not going to outweigh what has come in. But it's just a further diminishment of our entire electoral system. What are these people doing? All right, so I'm a little surprised by that one. I thought that was going to go our way because it's kind of obvious. But the left, very happy, celebrating that one. Yeah, and CNN right now is calling it a grace period for mail-in ballots. All right. So the good news with this is that Congress could change it. So if we have a useful Republican Congress, since, we control both houses and the presidency, and we can't rely on the Supreme Court to do anything for our elections, then maybe they'll pass some legislation on this. Election day. You can't end the game, end the basketball game, and then have one team just keep shooting hoops. Next up is the Fourth Amendment case about GeoFrence warrants. Justice Kagan with the opinion. That's interesting. So maybe she says it's allowed. I don't know Kagan's disposition on a lot of criminal law, but we're about to find out. So this is the Fourth Amendment case, which is about geofence warrants and whether or not the government gobbling up huge swaths of location data, whether that's a violation of your rights under the Fourth Amendment. 6-3, Alito dissents, joined in part by Thomas and in part by Barrett, and then Barrett has a separate dissent. Okay, so let's see what this one's got. Quick holding here. Police officers did conduct a Fourth Amendment search. So the Fourth Amendment would apply when they acquired Chatrie's location data from Google because an individual has a reasonable expectation of privacy in his cell phone location information, which I think I agree with that one. So that's, in other words, the government can't just gobble up all of your location data. That's a little bit surprising. I thought that the conservatives might be in favor of that. Alito and others are very, they're very kind of anti-criminal defendant. But let's see who joined in on this one. So Alito, Thomas, and Barrett in the dissent. Alito with the dissent. So it looks like 6-3. We've got Kavanaugh, Jackson, Roberts, Gorsuch, Sotomayor, and Kagan up in the majority. So 6-3 is what we've got here. And Barrett's with a separate dissent. So they would say it's not a search, right? This is more, the conservatives are pretty in favor of prosecuting defendants. In other words, criminal defendants don't have a lot of rights. Same thing with Scalia. Like Scalia, Thomas, they basically never see a criminal defendant that they're in favor of. But I'm not sure that I'm comfortable with the government just siphoning off all of our geofence data and then saying that that's not a violation of your Fourth Amendment right. We'll see what the decision looks like and what the holding ultimately entails. But 6-3. And so we'll come back on that one, maybe some differing opinions on that. But all right, let's drop that one also in the Google Doc so you can pull that if you want it. And this one's written by Kagan. So we'll see what else comes next, and then we'll unpack all of these together. But I'm generally more of a privacy-oriented person. I think that the government should reach a high threshold. I'm a criminal defense lawyer, after all. That, the government should really have to justify it getting data on you. And the geofence stuff is concerning. I think that there's a lot, there's going to be a lot of ramifications from that. If they were going to allow that to happen, then maybe they can gobble up a bunch of other things. So let's see what else we got. Not the last opinion. Alito's unhappy about it. Let's see what he says. I appreciate their arguments, but we love the Fourth Amendment. We want the Fourth Amendment to have a lot of weight to it without being chipped away at, with FISA and these other things. So we'll see what is inside that one. And if you want the data, just go get a warrant. Just go get a search warrant. It's not that complicated. And by the way, getting a warrant is easy. It's like nothing. You can get a DUI search warrant in like 30 minutes in almost every single location. Just go, oh yeah, I got a guy. Oh, sure, they'll fax it over to you. It takes about 5 minutes. So, all right, let's see what else we got. We've got some more decisions that are coming. And see if there's anything else good. There's a concurring opinion from Jackson, joined by Sotomayor. Was that on this one? Alito with a dissent. Jackson with a concurrence. Sotomayor. We'll spend some time on the dissent. We'll see what they say. And where's Barrett? So she's in the... So we got Kagan, Roberts, Sotomayor, Kavanaugh, Jackson in the majority. And did I count that right? Alito, Thomas, Barrett in the dissent. Sotomayor, Gorsuch. Yeah, okay, so there we go. That's the 6. Gorsuch is the 6, but he was not in the majority. He filed an opinion concurring in the judgment. Okay, so Gorsuch is a little bit, he agrees with the holding, but arguably not the rationale. So he's a little bit different, right? So he agrees this is the right outcome, but he has a different opinion as to why. So the rationale is ultimately going to be like a 5-judge majority rather than a 6. Jackson, a concurring opinion. She may be also with a different opinion. No, but she joined in the majority as well. So she agrees, adds a little flavor to it. Sotomayor joins her. Gorsuch did not join in the majority, but he just filed an opinion concurring in the judgment. Oh, and we got 2 more, Slaughter and Cook. So these are the companion cases about executive power. Let's see what this one looks like. And Slaughter was over at the FTC. Lisa Cook was over at the Federal Reserve. 6-3. Slaughter, 6-3. And the libs dissent on that one. So that's curious, which means her firing may be appropriate if they're all mad about it. She's FTC. We'll see if the same logic holds with the Federal Reserve with Lisa Cook. So we got 6-3 on Sotomayor. Hopefully they're dropping that decision soon. And that's it. So we're not going to get birthright today. So we'll come back on that. So let's take a look. We've got Lisa Cook pulled up and Slaughter. This one is Cook. And this one looks like the government loses. Let's see. Wow. So the Federal Reserve looks like it gets a victory, but the FTC looks like they lose. Let's double check that. Here, the government's application is denied. They have not shown that they're going to prevail. So Lisa Cook survives. And wow, that's like a 6-3, the opposite direction. So Roberts, Sotomayor, Kagan, Kavanaugh, Jackson joined. Kavanaugh and Jackson in concurrences. Thomas with a dissent, Alito, and Gorsuch and Barrett also dissenting on that one. And is this the reversal of that? So FTC, see what the holding is here. Lots of details on this one. Reversed and remanded. Yeah, so it looks like FTC can be fired, but Federal Reserve cannot be fired. Interesting. Also overruling Humphrey's executor, which really created a lot of this disgusting kind of intermediary branches. Trump versus Cook, they've got it at 5-4. Chief Justice again in Kavanaugh joining in the majority. So Lisa Cook looks like she survives. Okay. Let's see if there's anything else that drops on this. But okay, let's get all these queued up here. That's Chatrie. Let's go back up here. And I'm going to drop all of these links in the Google Doc. So this one is Lisa Cook. So you can grab these if you care to. And then I think we've got, what's this one? FTC. So this is Slaughter. All right, we'll start. Where should we start today when we get going? Yeah, looks like that was 6-3. And then Cook was 5-4. So interesting. Federal Reserve gets special protections. Thomas with a dissent. Court turns down the government's request to stop the lower court's ruling. So Lisa Cook can continue to stay in office. So the reserve is kind of outside control of the executive branch, but the FTC is inside control of the executive branch. And so that's Trump versus Cook. Yeah, maybe we'll start with those. We'll do FTC, Cook, then we'll go to election, then we'll close out with some Fourth Amendment stuff. And I think that's going to be it on the day. Humphreys is a big deal. Overruling that. Yeah, to accept any one of the Trump's arguments that the for-cause protection into at will, an interpretive leap that's out of bounds. And yeah, there you go. Yeah, our nation's tradition of central banking, which is protected from political interference, which is, personally, I think that's a loss too. I think the Federal Reserve it does have more historical precedent, like with the first and second banks of the United States. But at the same time, it is completely, essentially outside of any oversight. Why do we have this like fourth branch of government called the Federal Reserve that is not accountable to us? It handles our monetary policy for the entire nation, handles more than essentially some of the other branches do, because monetary policy affects all of us every single day. So, interesting day today. FTC can be fired. Lisa Cook cannot be fired. And let's see if that's it on the day, and then we'll get into it. Yeah, Slaughter looks like she's fired, which is good news. So here, who wrote this one? Let's just go back. This is the Slaughter case. And we'll get into all of these here coming up. This is a big decision, so we may just read the syllabus on this one. But yeah, so John Roberts delivered the opinion on this one, huh? Thomas joined as the all but 3B, Gorsuch with a concurrence, Sotomayor with the dissent. So Slaughter is gone, probably. All right. See if anything else drops for us. Yeah, so Trump can't fire Lisa Cook. Wow. So she stays in office to commit more mortgage fraud, allegedly. We'll see if that happens. Then we've got this one. This is the Cook case. And so who wrote this one? Let's just double check this before we dive in. Another big one. Roberts again with this one. So what's the distinction between the two? It's got to be the history of the Federal Reserve. So again, that's Roberts, Sotomayor, Kagan, Kavanaugh, Jackson. Then Thomas, Alito, Gorsuch, and Barrett. Wild. So Robert and Kavanaugh join with the libs again. And the dissent by Thomas would be a good one. So that will be well worth reading. But Federal Reserve lives on. Thank you, Supreme Court. So we got 4 decisions today. And yeah, an excerpt from the Slaughter case. This is the FTC case. Congress can't shackle the president for an agency like the FTC. The FTC definitely exists under the executive branch. Congress makes it a very difficult thing to do anything actually with that agency, which means it's not really under the executive branch. It's kind of in this gray area in the middle. So, all right, we'll see if anything else comes up. We do not yet know about the last opinion day. Roberts is still reading. All right. So how does that sound? I think we start with the FTC firing. We go to Lisa Cook, knock those out. Then we get election day, which was a loss as far as I'm concerned. And then we'll wrap it up with some Fourth Amendment stuff. I think that'll be a good way to approach it all. Roberts is still reading from his Slaughter decision. Yeah, and we'll see what the justification was. I'm going to just guess Roberts is trying to thread the needle. FTC is kind of a new agency created by Congress. The Federal Reserve is analogous to the original banks of America, which was supposed to be separate. And they love that Federal Reserve, man. Everybody loves the Federal Reserve. Yeah, not sure we're going to get birthright today. I think we're about done with the decisions. We'll see. Roberts is still reading, so he'll wrap up, and then we'll get into it. But I can't say it's a blowout win day. That election decision's a big bummer. And, we were kind of hoping that the Supreme Court would do something about the Federal Reserve. You may disagree with that as a policy measure. You may say, well, we do want some independence with the Federal Reserve. I've never bought those arguments. And there we go. No more decisions coming today. So the Federal Reserve, of course, have been around forever. Federal Reserve Act created it. It wasn't created by a constitutional measure like the income tax was. And they're supposed to prevent us from having like booms and busts and from inflation and from having these dynamic economic cycles. And have they done a good job of that? No. As far as I can tell, we still have those things. So what do we have them for? And maybe if they want a fourth branch of government, they amend the Constitution in order to make that happen, not just create an act, which takes away accountability from this body. It's like a board of governors. Is it like a separate Senate? No, kind of. Is it like a separate court? Kind of. And it strips us off from our monetary policy. And maybe you say that's a good thing if you're a financial bro out there. But if Trump wants to come in and cut interest rates to zero, and that causes economic disaster, we'll learn about that pretty quickly. But still, then he'll be held accountable for that. Then the president can be accountable to the people. Can you name anybody on the board of governors unless you're in finance? I can't. We got Jerome Powell. We got Kevin Warsh. Then we've got Lisa Cook. Who else is on there? Do they ever show up in Congress? Do they ever, show up on cable? Do they do, interviews? Are they accountable to us in any way? No, they're not. Nobody knows what the hell's going on over there. And then every year we wake up and there's more inflation. There's more economic uncertainty. Could we have decisions tomorrow? I was kind of hanging out to see if we get any details on what's coming next. Maybe tomorrow. But all right, so Lisa Cook survives. She's probably doing cartwheels and maybe committing more mortgage fraud out there. I'm going to go buy a couple houses. Yeah. Get low interest rates. No, it's my primary residence. I swear. We'll see. But we've got 4 decisions. We'll get to them. As soon as we close this day out, I want to make sure we're not missing anything before we just jump in. Yeah, and what's Ron Paul saying about this today? Probably not too happy. All right, so quick recaps. 4 opinions left. We had 4 decisions today. We had the Slaughter case. FTC looks like she can be fired. Congress illegally shackled the president. So that's a win. More in the unitary executive. We have a president, not a president plus agencies created by Congress, which is good. But on the Federal Reserve, Lisa Cook survives. So both of those were kind of companion cases. Then we got the Election Day case, which says they can count ballots as late as they want, however long they want. 5 days in Mississippi, but make it 50 days. Who cares? With some fiery dissents on that one, which is, okay, we'll stick to our plan. And then we've got the 4th Amendment case on geofencing, which I'm in favor of, even though it's the libs joining with some of the conservatives. Because I think our government already perverts enough of our privacy rights as it stands. But there may be some disagreement about that. All right, we're done for the day. Should find out soon when the next day is, probably the last day. All right, so we'll pause there and we'll get into this one, which is the Slaughter firing. So it's a big decision, and we'll get into the meat and potatoes of it and see what's going on. All right, so let's do this one. Big Supreme Court decision. Can the president fire people at the FTC? These so-called independent agencies that exist, created by Congress, that allow Congress to shackle the executive with all these conditions. You can only fire this person if this, that, and the other thing, and they have to serve for a term of time that extends this length of time. In other words, the president doesn't run the executive branch at all, is how it used to be until today. This case is Slaughter versus the president of the United States. As we know, Trump fired her as soon as he came back into office, and the court has now come down and issued their decision. And as we see here, it was delivered to us courtesy of the Chief Justice, John Roberts. He is joined by Judge Alito, Gorsuch, Kavanaugh, Amy Coney Barrett, Clarence Thomas joining in it as well, Gorsuch in a concurring opinion, and the three leftists, Sotomayor, Kagan, and Jackson, all in the dissent. So the decision, 6-3, split right along ideological lines, and a win for the executive branch. We do not want unfettered amounts of independent agencies just tarnishing America. We have three branches of government. You don't like that? Go amend the Constitution and create a third branch or some other solution. But you just can't make them up so that they exist in the middle of the gray area, such that they are not accountable to anybody. Here is the decision from Chief Justice John Roberts. He reminds us on America's birthday, nearly 250 years ago, the framers decided to vest the executive power in one person. A president, of the United States of America, all of the executive power into a president. That's Article 2, Section 1, Clause 1, right at the beginning. The choice was not made lightly. Within living memory, says Roberts, were the long train of abuses and usurpations of a king who reigned as a tyrant. That's from the Declaration of Independence. And indeed, several delegates of the Constitutional Convention did not want an executive. They wanted a multi-member council. What a disaster that would have been. He says, though, our unity won out during the debates. Our Constitution's drafters knew from experience that a plurality in the executive, the model that was used by most states at the time, not only diminished the activity, secrecy, and dispatch necessary for good government, but it conceals the faults and it destroys responsibility. They talked about this in the Federalist Papers. You need a person who's responsible so that there is a person to blame or to congratulate. With just one president in charge, they said there is no doubt on who to blame or who to punish if they fail. Now, 100 years ago, this court honored the convention's choice. We had a seminal case in Myers versus United States from 1926. There, we held that the Constitution grants to the president, quote, the general administrative control of executing the laws, including the same powers of appointment and removal. Because no one could execute the laws alone and unaided, Chief Justice at the time called Taft, he explained that for the court, the president must be permitted to select those who act for him and remove those who do not act for him. If you don't do that, it's going to make his job impossible to ensure that the laws are faithfully executed as required under the Constitution. Saying today, we confront one of several regulatory agencies that deviate from this model of presidential supervision. One of these is the FTC. Now, since its creation in 1914, the FTC has accumulated vast rulemaking, enforcement, and adjudicatory powers under more than 80 statutes. It's like its own court. Not only does it promulgate rules that carry the force of law, but it also enforces those rules against private parties. They collect civil penalties to the tune of billions of dollars. Its powers, however, though, don't actually belong to the president or his appointees. They instead belong to 5 commissioners, each of whom serves for 7 years and may be removed by the president only, according to Congress, for inefficiency, neglect of duty, or malfeasance in office. And so we hold that protection from removal is contrary to the separation of powers enshrined in the Constitution. It's like another branch of government. Congress creates an independent agency that doesn't exist under the executive branch because it strips from the executive branch key powers And that's illegal. It's unconstitutional. And we remember what happened here. When President Trump began his second term in January 25, the FTC was led by 2 Republicans and 3 Democrats. On his first day, he said, "You're fired." He designated a new chair, replacing Joe Biden's pick. And as is customary, the former chair, Lena Khan, resigned her seat a few weeks later, allowing Trump to appoint a new person. Of course, he had to go and get advice and consent of the Senate. But in the meantime, however, the FTC would be split down the middle. Now, that split came to an abrupt end in March. Trump then fired the 2 remaining Democrats, Rebecca Slaughter and Alvaro Bedoya. He did not assert that they were inefficient or anything. He said, "We don't want you here. It's inconsistent with our priorities, and you're removed. I've got Article 2 powers to run the executive branch, and so you're gone." Slaughter sued immediately, seeking declaratory and injunctive relief. She said, "No, you can't do this. You violated the Constitution. You violated the APA. All of this is outside the law." The district court granted her motion, saying, we're actually bound by this prior case called Humphrey's Executor, which it sounds like they're about to overrule here in a minute, which is a big win. Saying that case explained that there was an exception to this general rule. Humphreys described a multi-member expert agency as, quasi-legislative. It's quasi-judicial, and those are allowed. So the court said that what Trump did was, in fact, illegal and put Slaughter back in her seat. So then a divided court of appeals again denied the administration. They said, hey, all of this is settled law. A prior case called Humphrey's Executor says these are allowed. The court said you can't create these agencies. You can't do anything about it. Now, the dissenting judge in this, Judge Rao, explained that case didn't do this. That case does not license a headless 4th branch of independent agencies exercising considerable executive power. You can't do that. So we stayed the lower level decisions and have now accepted this case. Once again, the executive power lives in a president, says John Roberts, saying the whole executive power, the whole thing in just one person, was not to suggest that he could execute the laws alone and unaided, but it establishes a hierarchy. He doesn't run the whole government. He hires people to do it. There's different agencies. They all trickle up. James Madison wrote about that in the Federalist Papers. The idea that one president would be in charge was by no means a foregone conclusion. In 1787, just 10 years earlier, the colonists had thrown off the yoke of King George and his other governors. A bunch of state constitutions followed, and the framers left the model of having a multi-body executive branch. They had seen the flaws as states tried this, not states yet, but early colonies. The convention was determined not to make the same mistake as we saw below. So when delegates objected to the unity of the executive magistracy, the foetus of monarchy, they said, we do need to have a single person. We need vigor. We need activity. We need somebody who is responsible for these decisions. And so that the Constitution forged a new path was not hidden. Hamilton conceded only 2 states thus far have entrusted the executive authority wholly to a single man. And this was a change from how the colonies were actually operating at the time. So in opting, though, for one president, the framers did not opt for the president to work alone. They knew it would be impossible for one man to do the whole job, and they explained this accordingly. They said, you have to have officers. They put officers who help discharge the duties. And their very purpose, after all, was to help him with his job. Hamilton made the point, and it was debated. Now, because these officers were subject to the president's superintendence, they had to be removable by him at will. For one, that was just part of what it meant to wield the executive power, as it was understood at the time. Thomas Jefferson wrote about this in 1780. He said, the power of appointing and removing officers is inherent in the presidency. He who appoints may remove. And as to this power, the Constitution's words were carefully chosen. It was the president who would appoint the principal officers. The Senate would provide advice and consent. And if the framers intended to depart from this, they would have said so. And so appointment has a corollary power, which is removal. We wanted the president to be personally responsible for all of the agencies. And this was confirmed the very first year of the Constitution. The first Congress, they met in 1789. One of its first and most pressing tasks was to establish the departments. In doing so, they debated about removals. How do you remove someone? Others said the Constitution was silent as to this, but ultimately, the arguments made by the third group will sound familiar. James Madison led the charge. He said, I conceive that if any power whatsoever is in its nature executive, it is the power of appointing and overseeing and controlling those who execute the law. And so that means the power of removal must follow. If you can appoint them, you can remove them. Bunch of debate happened about that. And ultimately, the third group emerged victorious. They convinced the House of Representatives to delete a clause in the bill that said the Secretary of Foreign Affairs was to be removable by the president, for that language was there all along. It was his already. You didn't need to add in that this person is removable by the president because he already has that. It's in the Constitution. What they favored instead and what they got was a new clause that assumed the power of removal to be in the president as to establish a legislative construction of the Constitution. The bill as amended was passed and it was endorsed, and that's how it's been. Congress then confirmed that, and after the debates, more conversation happened that the power of removal was vested in the president. Lots of citations to that. Early presidents also followed it. Washington saw it as his indispensable duty to remove people who failed to live up to his expectations. Bunch of citations here. So did Jackson. Much to Congress's dismay, by the way. Unlike his predecessors, except for Jefferson, who did utilize the removal power sparingly, Jackson fired hundreds of subordinates for personal and partisan reasons. Nice. But even Jackson's most vehement critics acknowledged he could do that. Other senators at the time said, yeah, it's his authority. And so twice in the 19th century, we have reaffirmed this. The text of the Constitution is, quote, silent about the power of removal. We noted that. But it was very early adopted in the construction of the Constitution. It logically follows from being vested in the presidency alone. Our landmark decisions came years later, 100 years later. And that case arose from an unusual source. Under 1876 law, the president had the power to receive advice of the Senate, not only to appoint postmasters, but also to remove them. President Wilson fired Portland's postmaster. Someone sued. So there was a bunch of debate about this. There were scholarly opinions. Even Taft rejected this, reaffirmed that power can fire his subordinates. But Taft also emphasized it was not just the first Congress that had come to this conclusion. And in the wake of the Civil War, Congress sought to reverse this, but in the end only confirmed it. This reversal grew out of a serious political differences between Johnson, a Jacksonian Democrat, and congressional Republicans. And so they wanted to stop the president from actually being able to do it. A lot of history here. And then just 9 years after that case, then came the big one, Humphrey's Executor. The case first arose out of Roosevelt's decision to fire one of Hoover's appointees to the FTC. William Humphrey, 2 years into Humphrey's 7-year term, Humphrey lauded Hoover as the foremost figure in the world, a man who fought back against the demagogue. On the commission, Humphrey sought to do the same. He spoke to the press, described the FTC as a publicity bureau. Roosevelt saw matters differently and ultimately asked Humphrey to resign. Humphrey refused to do so. So Roosevelt fired him. One-line letter, didn't specify any cause for removal at all, including for inefficiency, neglect, or duty. Humphrey died and his state sued for back pay later. Now, on a day that the New Dealers would dub Black Monday, the court unanimously ruled against President Roosevelt, as it did in other cases. And this was a blow to the president that invalidated a bunch of his legislation. Having to contend with these cases, Justice Sutherland, writing for the court, started to reaffirm the president does possess exclusive and illimitable removal power of all purely executive officers. But then there are some officers that are not purely executive. Some are presidentially appointed who do executive things, but others don't. And the FTC is one of those that don't. And Humphreys could stay. That was because the FTC's duties were limited. He said the FTC was neither political nor executive. Such a dumb decision. Everybody's political. When the courts requested the FTC's help, it acted. It was kind of like a quasi-judicial body. So the court back then found it was valid. From the start, Humphreys was tethered to a highly circumscribed and almost fictional view of their role. By its own terms, it applied only to agencies that, quote, have no place in the executive department and are independent of executive authority and exercise no part of the executive power, which is all made up. Where do they live if they're not under the executive? So in later cases, although Humphrey's announced dividing line remained intact, we concluded, in fact, fell on the executive side of that line, where Humphrey suggested that the power to enforce only applied to quasi-judicial or entities that are in aid of the federal courts. We held the opposite. We had a bunch of cases here, Buckley versus Vallejo, INS versus Chadha. Soon enough, we started to see that Humphrey's, that terrible case, flunked even its own test. And all these other branches started to pop up. Fast forward another few decades, and Humphreys had even been further undermined. We had all these other cases where we again considered, can the president fire? In both of those prior cases, we reiterated the president can do that. In both cases, we emphasized that Humphreys needed to be cabined off to its own and shouldn't be extended. And so, in short, Humphreys has not withstood the test of time. While Humphreys was surely right to focus on the character of the office and talking about purely executive powers, we long ago abandoned the notion that there are some powers that are only partly executive. 40 years have now passed, and we have now recognized the FTC does actually exercise executive power. More than 200 years have passed since the Constitution, and the Constitution says the power is vested in a presidency. So if anything more is left of Humphreys, of this case that enabled a lot of this, we overrule it by Humphreys has for decades been a result in search of a rationale. And we have often said stare decisis, kind of following case precedent, is not an inexorable command. We can overrule ourselves, as it is its weakest in constitutional cases that are adverse to the Constitution. And so you can't make any sense of this. Quasi-legislative, quasi-judicial, they're all executive. And so for that reason, Humphreys is now far out of step with our cases, and it's gone. Little surprise, no one even knows how to apply it. Does it protect all multi-member agencies? Or only those that are balanced with like half Democrats, half Republicans? No one knows. So all that is left is reliance by Slaughter, who did get fired, is that. Slaughter argues that Congress has relied on Humphreys. We just overruled it, so now you're gone. That is the problem. Despite what Humphreys may say, independent agencies are not independent at all, in the sense that they are free of the United States and the president. Independent agencies are not insulated from the president. Good language here. Placing the power to administer laws and officers who enjoy freedom from presidential oversight does not deliver us into the promised land. Congress may well have relied on this case in extending these agencies, but no branch may rely on an adverse possession claim to power that the Constitution vests elsewhere. Interesting. So adverse possession is this concept in property law where you squat on somebody else's property. If you have some property, your neighbor has some property, there's a lot of land over there across the street from you, and you just set up shop on it, and it's open, notorious, like everyone can see you're doing it. It's very clear. It's for a continued length of time. There's this concept that you just own that land. It's adverse possession because we want property to be developed, not forgotten about. So essentially they're saying Congress came over and squatted on this and then seized it. You can't do that. It's anathema to the Constitution. So the dissent contends that we ignore the reliance interest of ordinary Americans. Well, we're all relying on the FTC. Quite the contrary, they say. When a power is exercised well, the people know whom to thank. When power is exercised poorly, they know whom to blame and whom to fire. That is the very premise of our government. We adhere to that system today, not in spite of a reliance interest of all Americans, but because of them. We're tired of the independent agencies that can do whatever they want. So with these principles in mind, this is not even a close case. The FTC's for-cause removal provision violates the separation of powers. Man, I hope Trump fires everybody. In its present form, the FTC enforces and administers 80 statutes, covers almost every facet of our nation's economy. Now, this is going to be rich when Roberts turns around and endorses the Federal Reserve. The tasks it undertakes are the very essence of the execution of law, precisely because of the president's power and his constitutional role. So first, the FTC has the power to promulgate substantive rules in the consumer protection realm. They can say things are unfair. They can also investigate businesses, open up adjudicatory proceedings. That is an executive power. They can file civil suits. As we've seen before, it's like a little DOJ. That's executive. And so the FTC unquestionably exercises executive power. Therefore, it must be controlled by the chief executive. It follows then that Slaughter was a subordinate, and in that regard, she can be fired. So because of all of this, we have no occasion today to define what the bounds of this power entails. As our precedents recognize, not all offices created by Congress necessarily come with executive or even sovereign power attached. And so relatedly, we've also left open the possibility that some functions traditionally handled outside the executive branch may be encompassed by the rules. As one example, here we go. He's talking about it, the Federal Reserve. So they got to protect it. We're going to protect the Federal Reserve because it's different than an executive body. To the extent that it follows the distinct historical tradition of the first and second banks, which influence monetary policy, none of those were subject to the president's control. Our prior cases don't implicate those arrangements. Our opinion today shouldn't be read to do so. And in the companion case that was released today with Lisa Cook, he carves that out stronger. Nor do we determine the fate of the officials before us. In particular, as the Solicitor General recognized, the permissibility of tenure protections for judges, non-Article 3 courts, bunch of questions are not in front of us today, so we won't rule on those now. But although she disagrees with our conclusion, she at least accepts our premise. It's a purely executive function. Then they must be removable at will. And the dissent is relying on comments from the Federalist on things that they said in the Federalist Papers. But we see no reason why those debates should take precedent over the decisions of 1789. When it comes to those debates, the dissent has little to offer beyond its efforts to limit the decision's scope. They say we should be able to create these independent bodies. That is why no one at the time saw the first Congress as having endorsed merely a default removal power. Madison said the opposite. James Madison, father of the Constitution, said because the executive power vested in the president includes the power to remove, the legislature has no right to diminish that. Talking to you, Congress. So there's no support of Slaughter in the early debates. The president can fire people with no support from the founding era. The dissent skips ahead a couple of centuries. And they note dozens of agencies. This is what they're mad about. Dozens of agencies are headed by commissioners or board members that are removable only for cause. And that should be entitled to significant weight. Since we've already been doing it for a long period of time, we should continue doing it. We have never endorsed such a practice. Makes perfect theory. We've rejected it many times. In fact, in Chatrie, that case, there were nearly 300 legislative vetoes adopted by political branches. But the popularity of a congressional veto only sharpened our view. We say the same thing today. To bolster its reliance on modern practice, they focus on a modern case, Humphrey's, but it defends the version of Humphrey's that does not exist. And so their ode to stare decisis is hard to reconcile. They want us to follow all precedent, even if that precedent is bad. We're going to decline to do that. And our Constitution, we agree with Roberts, obviously creates 3 branches. That's it. But only one president. The president is not all powerful, not by any means, but he is not impotent either, unless his name is Joe Biden. He and he alone is vested with the executive power of the United States. And to discharge the duties of trust, he's got to be able to fire people. Washington said that. Although it is up to the state and the Senate to decide whether to confirm those with whom the president would prefer to work, neither Congress nor the courts can saddle him with people with whom he cannot work. Subordinates who exercise the president's power are subject to removal from him. Then and only then can they remain accountable to the president and the president to the people. So the judgment of the lower court for D.C. is reversed. The case is remanded for further proceedings consistent with this opinion, signed by John Roberts and the majority in this case, 6-3. Karen Slaughter will go back down. She'll rely on her prior precedent, Humphreys, to say, you can't fire me. They just said, yeah, he can. And so that's the game. Now, Gorsuch saying, I cannot ignore the implications that follow. Congress is delegated because they're weak and pathetic. Congress is weak and pathetic. This is why they've done this, because they don't want any responsibility for it. They've delegated all these agencies legislative and judicial powers. They've allowed these agencies to make laws and decide disputes under them. But after today's decision, the president can effectively exercise all those powers too. Why would Congress have delegated so much? He says this is an important question. Because they're pathetic. This is what happens when you're ruled by like a mob of idiots. Nobody wants to do anything hard. So they just say, oh, let's just create a body. Let's create a committee. Let's create a commission. And the commission will handle everything. And we have no response. Well, I don't know. Why is the economy, what it is? Why do we have these booms and busts? Well, it's Federal Reserve. Talk to them. Oh, we'll talk to EPA. Oh, we'll talk to FTC. Talk to anybody except us, because we don't want responsibility for it. How will Congress respond now, if it even can? And what, if anything, will this court do about it? Yeah, we'll see. So Wilson and others, Woodrow Wilson, maybe the worst president in American history. They said we needed to reorient itself around efficiency. And we need a new model of public administration. And they need to be insulated. And we have to be ruled by the experts. And I think it was Buckley who had that great line, something like he'd rather be governed by the first 500 people in the Boston phone book. Boston was different at the time, than he would from the 500 faculty at Harvard, which I couldn't agree more. Many of the Harvard idiots who have been in charge for my entire life are the reason we're in the position that we're in, invaded and inflated. So he says, what are we going to do with this? Goes through some more history. We got a big problem. If politics, rather than a neutral technical expertise, landed Humphrey the job, they then made him a target. And if the Wilsonian vision of agencies run by experts, which are not experts, they're idiots. They're self-defined experts. And they're the ones who told us 100% effective. Yeah, we got it. So Roosevelt fired Humphreys, lots of here from Gorsuch. But Congress then tried to insulate agencies from direct presidential control. The result, independent agencies today hold tremendous sway over the nation's affairs. They regulate our businesses. They regulate our financial markets. They set rules for the internet and airwaves. They decide how we light our homes. They invade our country without us voting on it, nobody being held accountable. They determine what toys our child will play with, how we interact with each other. Nobody knows who they are, and they're governing us. It's not the people. So these agencies even have de facto authority to create new crimes. Congress has given them all this power. Would Congress have gone so far down the road if we didn't permit them to do that? Maybe. Maybe they'll continue to. But the court's decision today may take aim at removal protections in one part of Wilson's horrific vision. But as we've seen, other parts were never fully materialized. It was never the case that neutral experts alone led the agencies that Congress created. No, they're partisan hacks and idiots, and they just pretended to be nonpartisan and on some stupid committee. And it was never true that those agencies were insulated from politics, obviously, nor can the demise of one more vestige of Wilson's ambition come at a surprise. And even as they acknowledge the president's, Wilson and others, there was tension with the Constitution. So even if today's decision, writes Gorsuch, represents an important step back toward the Constitution, it's also worth considering the implications for Wilson's plan, Congress has not just assigned executive law enforcement powers to these agencies, it has delegated them lawmaking and adjudicative functions. Today's decision may not have occasion to address those directly, but it carries weighty consequences. This is Gorsuch warning Congress. The whole of the president's authority also may be greater than the sum of the parts. So you guys gave the president all of this power without even realizing it, right? Congress said, we're going to delegate our constitutional powers to these bodies because we're cowards and we don't want to actually govern. Now, with this holding, they are having to reconcile the fact and realize they just gave that to the president. Okay, they were willing to give that up because they're like, oh, it's an independent body and we're going to appoint all these people and blah, blah, blah. But now Gorsuch is saying, do you realize what you've done? Do you know what you've just handed the executive branch? Total control over all of these independent agencies. They're his now. He says, presidents now will enjoy waxing authority over all of those areas and more. Let's go. And this is great because we still got 2.5 years left. A business out of favor with the party in control of the White House might be able to stave off an FCC investigation, but can it survive a subsequent FTC rule? What about an in-house adjudication of OSHA or a prosecution under the SEC? Not to mention the now coordinated powers could do disfavored individuals who lack the resources to fend off all of these attacks. So now, what? And by the way, this is a double-edged sword. So if we lose the presidency, we're in big trouble because now they can all do the same thing in reverse. But it may be true that after today, there is no more fourth branch of government. Amen. But the fourth branch's powers still exist. Now they've been reassigned to the president. So Congress, this is your wake-up call. You better claw that power back if you want it. Otherwise, it's in Trump's hands now. If all that weren't enough, presidents have many other ways to consolidate their influence. Here's a couple of examples that he walks us through. And presidents can adjust civil service laws and write policies. And so now you have given him your powers and he'll run with it, which may not have been your intention. So if you allow this, who will address it? He says, well, maybe the most natural answer might be Congress, aware now that this has been a flawed basis on which to delegate power. They've handed it off. So what's the most straightforward response? Congress still passes tools. They can influence presidential decision-making through appropriations. But once they delegated these things, now they may require a veto-proof supermajority to retrieve, right? It's a one-way consequence ratchet. They ratchet here, more independent bodies, more independent bodies, more independent bodies. And going the opposite way, the president might just veto you. No, you can't take that away. It's mine. F you, I'm keeping it. Perhaps then, if any real response is to come, it will have to come from this court, and that's hardly unfair. To be sure, Congress had a hand in creating the problem that we now see, but this court bears responsibility as well. We allowed Humphreys to exist for 100 years, and it was this court that sat by while Congress delegated its vast legislative and judicial powers to one independent agency after another. This is great. Congress, take your power back. That's the whole point of checks and balances. But they're just weak and pathetic. So they created these other bodies so they don't have to do anything. And it is this court that today allows the president to remove those agencies. And now he's running Congress. I'm Congress now. If the task of fixing the problem belongs to those who made it, we've got some work to do. But the Constitution allows us to do this. We have 3 branches, not 4, not one just led by the president either. Each branch bears the authority and the responsibility to exercise their powers. Congress must make laws that govern us, and the executive must execute those laws, and judges must decide. Fortunately, this court has many doctrines that we can use to rein this in. There is a concept called the non-delegation doctrine, which means you can't actually, if the Constitution says this is your job, you can't give up this job. Of course, Congress can enlist experts to advise in its work and do other things. But I think this is a petition for Congress to otherwise, take its power back, stop delegating all this stuff out. The only real question is whether we will use these powers. And whatever merit those objections might have from a bygone era, they're back. And The court today is now taking a notable step back towards the Constitution by saying the president can remove. That is restoring order. At the same time, it would be a grave mistake to think the step is enough on its own. The fact remains, Congress has endowed formerly independent agencies, they're no longer independent, not just with executive authority, but with enormous legislative and judicial power as well. And now the president enjoys control over all of those powers too. And so this is kind of a tyrannical concern by bundling up power into one branch, which is not what we want. We want separate entities with their own roles that check each other. Congress should have said from the very beginning, we're not creating some independent body. That makes us weaker. But they want to be weak. From here, the only sure path to finish this is to restore legislative and judicial powers where they belong, in Congress and in the court. And that would mean that a lot of these agencies just have to go bye-bye because they're siphoning from Congress. They're siphoning from the courts. It is time to return all the way to the Constitution signed by Gorsuch. That was a good concurrence right there, I will say. So we get this now. The dissent, they've already articulated their dissent, so we don't need to spend a lot of time on it. But it's long. It's about 48 pages. And they just say, we always want independent bodies. Over 140 years, we've been doing this for a long time. And so now we're reversing this. We've been doing this forever. It's like a Roe versus Wade argument. Well, Roe versus Wade was unconstitutional because it was pulled from the penumbra. But we've been doing it forever, so we should just keep it the same. So the answer is no. They lose. So the three libs, we get the dissent. 6-3, Sotomayor, Kagan, and Jackson in the dissent. We've been doing it forever, so we should continue to do it forever. And there's a historical tradition of doing it. But not anymore. Back to your seats. Congress, this is where you sit. Executive, this is where you sit. And the courts have a big role too. But these independent agencies have been stripping it away forever. And not anymore. And so this is a bummer for their side because Trump is the president at this time. And now, as we just saw from Gorsuch, formerly independent agencies, all of those that have been articulated, there's a good basis that they belong to Trump now. And the concern, of course, is it's a double-edged sword. So when the Democrats, if God forbid they come back in, it's going to be their power, which is why we want the separate, but equal branches of governments where they each fight to the death for their powers, not give it up in this creation of a massive gray area. So good decision. I would say the biggest win of the day, 6-3. Independent agencies are now dead for the most part. Humphrey's executor now overruled, and constitutional order is one step closer to returning to form. We'll see what the screeching and the fallout is on this one. Thanks for continuing to join us as we do. All right, now there was an update I saw come through. So tomorrow we'll be back. So we still have 3 decisions to get to here today, but tomorrow will be the last day. So we're going to have birthright citizenship tomorrow. And based on what happened today, you can see why I'm nervous about this. So mark your calendars, come back tomorrow morning, 10 a.m. as well. We're not done yet. We got 3 more decisions to talk about, but tomorrow we're going to get birthright, the 2 trans cases, and then the campaign finance case about free speech and limitations on that free speech. So, all right. So we'll come back on that tomorrow. Thanks for subscribing. If you haven't already done that, we're going to have some big ones tomorrow. Now, let's talk about this other one and see how they squirm their way out of this one. We had a very nice decision that we just talked about saying no independent agencies. And just think about this. Where's Gorsuch on this one? He's in the dissent. Yeah. All right. The dissents should be really good on this one. All right. So let's get into it. Let's start with our red pen. and confirm. Yeah, this looks like it was a 5-4. The Federal Reserve survives. We remember when President Trump came into office and fired Lisa Cook, the woman who allegedly committed mortgage fraud, by saying that she had multiple primary residences in order to get a benefit on her loan and interest rates. The same person who's on the Federal Reserve Board of Governors, who sets interest rates for the rest of us, was trying to get a little bit of a better deal. And then once she got caught by Pulte and others, she said, oh, it's oversight. It's administrative error. There's no problem here. Don't get mad at me. Trump said, no, you're fired. And then she sued to keep her position in the board. Now, the case has emerged all the way up to the Supreme Court of the United States. And in a 5-4 decision, we've got John Roberts joining in with the libs, along with Brett Kavanaugh, saying you can't fire Lisa Cook, at least not at this time. Now, this is on application for a stay. So the lower level court made decisions that Lisa Cook can stay in office. Trump said, no, stop that from happening so that we can ultimately fire her. And the court said, you are denied. Now, let's get into it, because I think the dissents are going to be very, very interesting and illustrative. But here's how the holding was broken down. So Chief Justice John Roberts, who just wrote the other decision in Slaughter that overruled Humphrey's Executor, which said there are no independent agencies, that the FTC person could be fired, named Slaughter, she's gone, and Humphrey's Executor was overruled. He found in favor of a unitary executive that the firing removal power lives with the president. But in this one, not with the Federal Reserve, because everybody loves the Federal Reserve. So Roberts joins in with Brett Kavanaugh here, so two on the right, who are then supplemented by the three on the left, Sotomayor, Kagan, and Ketanji. All in the majority of 5. Then we've got Clarence Thomas in the dissent, Alito with his own dissent, and Alito's being joined by Gorsuch and Barrett for a total of 4. So the libs win this one, having peeled off 2 of the reds, Kavanaugh and John Roberts. Great. So here, let's see what's going on in this one. Once again, from John Roberts. He said, last August, for the first time in the Federal Reserve's 111-year history, there we go again. That's like a leftist argument. Well, we've been doing it forever. The president attempted to fire one of its governors. A few weeks later, a federal court issued an injunction to stop him from doing that. And so now we decide, should the firing prohibition, should Lisa Cook still stay in office pending the conclusion of the attempted removal? He continues, Roberts. He says, our nation's first de facto central bank predates even our Constitution. Through the early years of the Revolutionary War, the Continental Congress had been forced to print so much money to finance the war that its currency had become all but worthless. And so they had to do this. To solve the problem, Congress realized it would have to tie its own hands. We can't spend money because we're like idiots with it. We have to place the power to create money elsewhere in an entity that could serve as a principal pillar of American credit by the ties of private interest. So give us certain authorities, but not the power to spend. How long has the Federal Reserve been in place? And have we gotten our spending problem under control? No. Thus was born the Bank of North America. Its structure was unusual. It was to be owned in part by the government, at least at first, and in part by the public, run by directors accountable only to private stockholders, and yet tasked with public purposes, which was the maintenance of a sound national currency, which we arguably marginally have. Such a bank was a necessity. Thomas Paine later wrote, he said, for what with the depreciation of the currency, the slow operation of taxes, and the petitions to be exempt therefrom, the Treasury had no money. The government had no credit. Hamilton said the same thing. We need this to happen. Hamilton was the father of the banks. The aid afforded to the United States during the remaining period was of essential consequence, says Hamilton. But the bank was short-lived as a national institution. It accepted state charters in 1782. Its national charter lapsed alongside with the Articles of Confederation. And then another bank quickly followed. 1791, at Hamilton's urging, the first Congress chartered a bank. It was the first Bank of America, with similar goals of the Bank of North America and similar degree of independence. It would also be owned in part by the federal government, run by directors accountable only to private stockholders. Now, to Hamilton, this was key. If we want confidence, it shall be private, under private, not public direction, so that the Congress doesn't succumb to the temptations of momentary exigencies. How much debt do we have right now? Where'd that debt come from? Under a public direction, Hamilton feared suspicion of political manipulation. It would continually corrode the vitals of the bank. And although the charter of the first bank was allowed to expire, it only took 5 years. Congress then entered another one. As Chief Justice Marshall remarked in our court's first major decision on the breadth of the enumerated powers, Marshall, who is John Roberts' favorite justice, a short experience of the embarrassment to which the refusal to revive the bank exposed the government to severe financial instability following the War of 1812. Have we had any financial instability since the Federal Reserve was implemented? That necessity led to the second bank, encouraged even by Madison, who used to be an ardent foe. And like its predecessors, the second bank was not to be controlled by the federal government. It had 25 directors. Only 5 were appointable and removable by the president. The remaining 20 were appointed by private stockholders. And the second bank's independence, however, was to prove its downfall. Unlike Madison, Andrew Jackson had not and would not change his mind on the wisdom of the national bank, at least one that he could not control. He savaged the second bank, shout out, as a hydra of corruption that I'm coming to slay. So in 1832, when Congress passed the bill to extend the second bank's charter, Andrew Jackson vetoed the crap out of it. He said he refused to make the rich richer and the potent more powerful at the expense of the humble members of societies, the farmers, the mechanics, and the laborers. And as Alexis de Tocqueville noted, the common people rallied around the president. Jackson easily won re-election. And that was the end of the second bank. And he's going to say, then we had all sorts of problems. Then it would take almost 80 years before Congress would try again. And only after an era of ruinous financial panics have we had any of those since the Reserve. The ones of 1837, 1857, 1873, 1893, 1907. These crises were no in part attributable to Jackson's crusade. Without an independent bank, there was no way to contain the damage whenever a major institution fell. No lender of last resort that could allow sound banks with good but temporary access of cash problems to fix the problem. It was a system devised for a fair weather, not for storms. It took the panic of 1907 then to force action. A failed attempt by speculators to corner the copper market led to the collapse of banks. Have we ever had banks collapse in modern America? A bipartisan congressional commission eventually recommended the creation of a central bank to assume serious duties. And what emerged was the Federal Reserve System, created in 1913 by the Federal Reserve Act and then restructured in 1933 and 1935. Right around the same time, the income tax came into play. These regional banks, called Federal Reserve Banks, are privately owned and operated by commercial banks of the areas. Above those banks are 2 national bodies, the Open Markets Commodities and more. And like the directors of its 3 predecessors, the governors do not serve at the president's pleasure. They instead serve staggered 14-year terms, and they're only removed for cause. Yeah. And they've done a great job. We've never had any bubbles or busts or any financial concerns where banks need to be infused with billions of dollars like the Lehman Brothers or Silicon Valley Bank or the dot-com bubble or the George Bush Great Recession of 07, 08. Like, everything's perfect ever since. Lisa Cook was appointed to the Board of Governors in 22, at first to complete only the final 2 years of Janet Yellen's term. Then a year later, Biden nominated Cook for 14 years. Lisa Cook, the alleged mortgage fraudster. In the normal course, she would not leave until 2038. And over the course of 1 week in August, however, she got called into question. Bill Pulte, now the director of national intelligence, who has most of the Republicans in Congress freaked. The letter was sent to her saying, "Hi, Pam Bondi. Lisa Cook probably committed mortgage fraud." According to mortgage documents obtained by the agency, it says Lisa Cook may have falsified bank documents and property records to acquire a more favorable loan term, a better interest rate, the same interest rate that the Federal Reserve sets for us. She wants a better deal. So less than 30 minutes later, Trump posted on social media, "Cook must resign now," and linked to a news article about Pulte's letter. 2 days later, Trump told reporters what Cook did was bad and that he would fire her if she doesn't resign. She didn't. 3 days after that, Trump reported to fire her for cause. In a letter to Cook, he stated that he had reason to believe that she may have made false statements on one or more mortgage agreements and said the American people need to have confidence in our members on the Federal Reserve. But there's nothing we can do. They get 14 years. It's just the end of story. But he lacked the confidence in her integrity. And in light of the potential criminal conduct and gross negligence, he said she needs to be removed immediately. So Lisa Cook sued. She said, "That's not for cause. I can commit mortgage fraud. Who cares?" And in any case, she said the president complied with the statutes, did not do it, and so she can stay. District Court agreed, stopped the president from firing her. It then turned to her claims. It said the president had failed to state a legally permissible cause to fire her. Cause only refers to an official's in-office conduct. Okay, so since she made the mortgage fraud before she got into office, now she's trustworthy and should definitely manage America's monetary policy because she did it before. And I wonder how far that extends. What if she committed credit card fraud? What if her whole financial endeavors are completely fraudulent? It wasn't in office. She did it all before she got there, and so we just excuse it. It all predated her tenure. And as to the second, it held that the Constitution entitled Cook to notice and a hearing before her termination, and so the procedural process was not followed, and said she's going to face irreparable harm, so she's not fired. They went up to the Court of Appeals. They said, nope. She can stay. She can only be removed for cause. She has a property interest in the position, and she has due process rights. So the government came to us. Now, this case comes not directly on the merits, right? So we're not at the end of this. It may come back at some point, but we're only on the application for a stay. Trump said, "Let me fire her now," while this litigation continues. The standards here are already articulated. In our view, according to Roberts, the government has not shown that it is likely to prevail on various legal arguments. Great. Government says three things. One, that removal for cause under the law is not judicially reviewable. If I say it's cause, it's cause. If the court says it's not cause, that is the court making a for cause determination in lieu of my role. That's a usurpation of my power. And that even if it is removable, it's a very low bar. And it relates to ability, to fitness, and to competence, not to committing a crime or something while in office. And that even if the government did not show cause, she is not entitled to remain in office while the litigation is pending. And we disagree, says Roberts, along with Ketanji and the others. On all 3 points, to accept any one of those arguments would in effect transform the Federal Reserve and the for cause protection into at-will employment. And Congress did not want that in the statute. It's not an amendment. The Federal Reserve is not an amendment, unlike the income tax. And it would go against our nation's tradition of central banking protected by political interference. And so therefore, we deny the government's application. And so Roberts, he's just inconsistent as far as I can tell. Compare this to the Slaughter case. There is a tradition in America of having independent agencies. It's been going on for 100 years. That was the whole point of the dissent. It just wasn't long enough of a tradition for John Roberts. So because this was a longer tradition, it's not touchable. But with Slaughter, because Humphrey's Executor and the others came out later, it wasn't during the founding era, then that is attackable. It's not a consistent distinction. This is like a fourth branch of government, the same type that he just ridiculed in the Slaughter case. But now he's like, oh, he's all for it because there was a national bank before and a national bank after the founding. And that's good enough for him. So the government, but not Thomas, contends that the president's determination of cause is wholly unreviewable. But we don't see anything in the law that says that. The statute says that each member of the Board of Governors shall hold office for a term of 14 years unless removed for cause by the president. Whether a governor should be removed, it is true, is a decision only the president can make, but that doesn't mean that he may make the decision for any reason or for no reason. Even when the law delegates that authority to the executive, we have explained our role is to independently interpret the law to effectuate the will of Congress within the constitutional limits. Congress could, of course, afford the president the power to remove them at will, or Congress could exempt the president and the removal of governors for cause from judicial review, but they haven't done that. So the government appears to concede that some review is available, but the only way for us to see what the cause is to understand what the word cause means. The government looks to another case, and it's about causes prescribed by law. They talk about that Reagan case. They talk about common law. Let's fast forward to his holding. But we see no indication in the common law that it should be for any cause. So even if the president's determination is judicially reviewable, cause then is very low. In the government's view, cause includes any concern, ability, fitness, competence that the president has. That excludes a mere policy disagreement, but even a concern about integrity could be the cause. Cook says no, cause is very high. In my view, it is only for the existing causes of executive officers that are already articulated. It's got to be in office, she says. Poor performance, inefficiency, neglect of duty in office. But the president didn't allege either. So we find neither of those persuasive. So we're not going to use her standard. We're not going to use Trump's standard. Although neither the government nor Thomas say as much, both seem to acknowledge that Congress enacted this statute against the backdrop of the common law. And Black's Law Dictionary and other dictionaries are being referenced here. So it's something more like substantial, reasonable, and just. Like that's what the standard is. It's not in office, but it's not for Trump like any, almost any cause of integrity or ability. And so if the government in Thomas's test is too lenient, Cook's is too stringent. So maybe she can be fired for this conduct, but we're just not there yet. Cook argues that we should interpret cause to refer only to specific causes that are in other statutes. But we don't see why that should be true either. It is true, of course, that some statutes by their own incorporate an external body of law if it references it, but this one here does not. It refers to cause generally. So what does that mean? So now we reject both sides. We need not fully demarcate the contours of cause today. Weak. For present purposes, it is sufficient to observe that any definition of cause in this context must reflect the Federal Reserve's unique historical status and role. All right. So they're going to punt. Like its predecessors, the Federal Reserve operates as a deliberate remove from the ordinary process. It sets its own budget, free of congressional control. It consists in large part of privately owned banks, and its policies are set not only by the governors, but also by representatives of the private banks. Indeed, it is their independence that allows it to pursue a mandate of maximum employment, stable prices. How stable have prices been? Moderate long-term interest rates, and goals that may be thwarted if it becomes at the disposal of our government. Not only the fact of independence, but the appearance of independence is key. So this counsels against a substantial threshold for cause, which means it shouldn't be too high. It is true, of course, that cause cannot be reduced down to something low, but whether for cause removal exists in any situation will depend on the seriousness of the allegations of the misconduct and whether there is any nexus that may exist to the governor's professional duties. Okay, so if this is the new test, Lisa Cook might still be fired. Mortgage fraud is a serious offense. It's a crime. And it has a nexus to her job duties because she sets interest rates on the Board of Governors and was lying, committing fraud, committing a crime to get a lower interest rates on her properties that we, the people, would never enjoy, if we're honest. The key issue is whether the cause assigned truly implies an unfitness for this place, or whether it simply represents an effort to secure a more congenial replacement. So it's not her standard, and it's not Trump's standard. Our review is deferential. but we're not required to exhibit the naivete from which ordinary citizens are free. So without any of these constraints in place, any perceived or alleged misstep, past or present, could provide a ready pretext for a governor's removal, a fact that he would surely know and that would weigh surely on him as he decided what to say and how to vote. Nothing could be more corrosive to the independence of that Congress sought to preserve. Okay, so this is all kind of the silver lining in all this. Let's not forget, this is on application for a stay. But it's not saying that she stays indefinitely. They're going to remand this back down. They're going to apply a standard more like this. Her standard was, I'm only in trouble for stuff I did in office. They said, no, you're not. Past or present, that might count. Is there a nexus to your job duties, your professional duties? Absolutely. This is about interest rates. So she may ultimately be fired, just not right now. Even if the determination of cause is judicially reviewable and the definition of cause imposes a substantial threshold, the government says federal courts cannot grant a preliminary injunction right now. You have to let us fire her. On their view, all you can do is wait and we can back pay her if she was wrongfully fired. The law doesn't require that. And Justice Thomas is relying on some sort of treatise. And so in the meantime, equity could ensure that her title and her position is protected. He walks us through other case law. Now, in some, a court may order that a removed governor remain in office pending litigation. Otherwise, a president could remove them even while litigation was ongoing, and that could be a long time. And there may not even be a cause for that. So that would interfere with the independence of the body. So having rejected all of the government's views, we may decide this application on narrow grounds. No matter the precise definition of cause or the scope of our review, the president failed to give Lisa Cook the procedural protections. Without these protections, she could not properly dispute any of this. And so he did, without authority, the firing. And also, she's entitled to notice in a hearing. He said, I did give her notice. I posted it on True Social. Doesn't mean that she's entitled to a full audience with the president or a full-blown trial, but all is required is an opportunity to be heard in their defense, in Lisa Cook's defense before the firing happens. Government doesn't want that at all. They say that's an additional requirement that's not in the law. But they say it is kind of in there because of this phrase, specified clauses. And if it's a limitation on the firing, then there needs to be an opportunity to contest that justification for the firing. More from Roberts. He continues to dunk on Thomas. We'll get to Thomas in a minute. He says these other cases are better authority, but we don't need to define these background rules. We don't need to repeat ourselves. We've already made these arguments before. And let's see where he gets. Now, he's talking a lot about Thomas, so we'll just get to Thomas and see what Thomas says. Now, as a last resort, the government half-heartedly contends that Cook, in fact, received due process after all. They say they did get notice. True Social. They say Trump's post was enough. And once he posted, she could have objected. He said Cook must resign now. That's not going to do. They say Truth Social is not due process. At minimum, Cook was entitled to some explanation of the evidence, some avenue in response, a deadline with a response due date. She didn't get that. Therefore, it was void. And it's an open question what happened here, writes Roberts. And indeed, did she commit gross negligence? Did she commit deceitful and potentially criminal conduct? Those are factual issues. We can't determine those things right now, and certainly not on the sparse record here. Doesn't even include the mortgage documents. We haven't even seen those. There is no evidence about anything that may be relevant. And so only after Cook has had the opportunity to respond to the charges made against her, however brief, however informal, can a final decision be made. And only then can the courts assess the validity and the sufficiency of those charges. And if you want to change any of this, you can have Congress do that. That is why we cannot accept the government's contentions here. Otherwise, you can remove anybody at any time for any reason without any notice at all and without any judicial check after that. And so we can't do that. That would turn a for-cause protection into at-will employment. And to be clear, once again, the ultimate question of whether the president can remove Cook for cause will depend in part on the facts. And in this opinion, we have not addressed the facts, as they have yet to be found or analyzed under the relevant legal standards, which again is somewhere in the middle. Rather, we have simply addressed the arguments about the appropriate legal standards under which the facts must be evaluated, and so the application for a stay is denied. Signed by John Roberts, joined by Kavanaugh, Sotomayor, Kagan, and Ketanji. And as I mentioned, the standard is going to be interesting. So this will go back down, and then they'll apply. Where was that section? Man, we read a lot today. Way up here. Consider the seriousness of the misconduct against the nexus of the professional duties. More than just a congenial replacement. And it includes past conduct. So it'll go back down and we'll have a new standard. So whatever the Court of Appeals did and the district court did, they're going to have to review it, apply that standard, and then measure out Lisa Cook's conduct against that new standard. So she may ultimately go, but not yet. Now, here is what Kavanaugh said. And let's just get down to Clarence Thomas. Actually, he's very short. Kavanaugh's very short. 2 points. Join it in full. Today's ruling does not decide whether the president may lawfully remove Cook for cause. The ultimate decision about cause will largely depend on the facts. And those facts are not in evidence yet. The court's opinion is just simply settling some of the procedural and legal grounds under which they may determine and assess the facts. Courts may then assess the validity and the sufficiency. So don't be too mad at us because she may be gone ultimately in the future. Second, in establishing some of those legal concerns and procedural grounds, we affirm the long-standing historical practice and understanding of the Federal Reserve. It's an independent agency that is protected. All of that is consistent with the Constitution, which is crazy. It's like a fourth branch of government. The government expressly acknowledged and did not dispute this in their arguments. And they also stated that their independence is to protect the governors. And so they weren't going as far as like the FTC case. He's like, we're not nuking the entire Federal Reserve. They weren't even asking us to do that. So I agree with the court, moreover, that we should not leave open the question of whether the Federal Reserve can remain an independent agency in the wake of Slaughter, the one we just decided. After Slaughter, there is a clear choice. Either the Federal Reserve may remain independent. So Kavanaugh gets the contradiction here. Slaughter just said FTC, SEC, FCC, all of these things are no longer independent agencies. There's one executive branch. It lives there. Either the reserve may remain independent with the governor's removable for cause, not at will, or it may not. Leaving that question open would create significant uncertainty about whether the court might soon eliminate the Federal Reserve's independence and thereby expose the reserve to political influences and jeopardize the efficacy of monetary policy. What is the efficacy? Even temporary uncertainty about the status could spark political upheaval, including confusion about whether the president could remove multiple of them, as well as turmoil in the U.S. and world economies. Now, I would not go down that road. I would not risk destabilizing the U.S. economy just so that we can further mull over that issue in various permutations that we've been thinking about for many years. As the court's opinion explains and the government agrees, the Federal Reserve occupies a unique role in the government, and they maintain critical responsibility for the stability and the success of the economies around the world. Most importantly, for constitutional purposes, the Federal Reserve is distinct in its historical tradition, as Roberts talked about. So in my view, in light of that practice and precedent, the Federal Reserve may continue as an independent agency after Slaughter. If the reserve's for-cause removal protections are to be eliminated, that change must occur in Congress. And so in short, like the court, I see no good reason here to unsettle a critical constitutional question that has long been settled and that should remain settled. And so for those additional comments, I join the court's opinion in full. And they say only Thomas says under Article 2, The reserve may not remain an independent agency and the governors should be removable. We love Clarence, man. Thank you, Clarence Thomas, MVP. So speaking of Jackson, fast forward through that one. She doesn't know anything anyways. So let's get down to the Thomas in his dissent from the man himself. From Clarence Thomas, dissenting in judgment. Part of the four in the dissent, joined by Gorsuch, Amy Coney Barrett, and that's it, four. The President of the United States seeks relief from an order that restores a principal executive officer to her position. Trump fired her. Biden appointed Lisa. The board of governors, unlike the Federal Reserve banks, is an executive agency. After Trump was elected, he said, oh, Cook may have committed mortgage fraud. That's a federal crime, punishable by 30 years in prison. So he fired her. He did so pursuant to his authority under Article 2 and fired her for cause. So then Cook sued, reclaimed her office. She said that her office was literally her property and that her property was deprived of her without due process of law. She said her apparent mortgage fraud was not cause to remove her, and cause requires notice and hearing. So the lower court agreed with her. And today, this court denies the president a stay of that, allowing her to continue in her position. But the court's decision is incorrect. Cook's office was not her property because in this country, government officials do not own the public offices in which they serve. An apparent mortgage fraud was a cause. Simple as. And the law authorizing the president to remove Cook for cause says nothing about a notice and a hearing, and so it doesn't require a notice and a hearing. Any other result would violate Article 2 of the Constitution, the president's powers. He may remove people at will. The court makes many policy arguments for an independent bank that exercises executive authority free from accountability, but those are arguments against the Constitution. He says the federal courts also lack the authority to enter relief. This court has held that a plaintiff cannot obtain relief against anyone, let alone a sovereign, without a right of action. But now it rules that Cook may obtain such relief without identifying one. It is held that federal courts lack equitable authority to balance this out, to interfere, to shove people back in their offices. But it recognizes an exception to that rule for Lisa Cook. And it is held that Congress and the judiciary cannot encroach on the president's exclusive and preclusive powers, which include his power to remove officers like they did in Slaughter, but then it prevents the president from exercising that power here. Although the court expresses concern that the president removed a board member for the first time in their 111-year history, same crap they hear all the time. Roe versus Wade was on the book for 70 years. How can you do that to us? It expresses no such concern that it today upholds an injunction against the president's removal of an executive officer for the first time in the Constitution's 237-year history. So I see your 111 years, and I call for 237 years. Eat it. I respectfully dissent. And it's exactly right. The Federal Reserve was created by statute. The Federal Reserve Act created this independent body. And look, man, it could be way worse. I don't know. Maybe if we didn't have them and we have a bunch of, politicians coming in and governing things, maybe we look like Zimbabwe with wheelbarrows full of dollars. Don't want that. But the justification for the whole system is that we never have, we're going to have good currency, meaning we're not going to have inflation. It's like $1 million to get a house now in like 100 cities or whatever the numbers were. There was some report on it. Your dollar, when I was a kid versus now, is dramatically different. Now go back to the 70s, then go back to the 50s. Our dollars have been inflated into oblivion. We're like $40 trillion in debt. What the hell are they doing? If they're doing a good job, boy, I'd hate to see what a bad job is. We've had how many booms and busts, how many bubbles, how many bank failures that needed to be supported, TARP, Trouble Asset Relief program, and the mortgage all the things. It's nonstop. So here's what Thomas says. I'm glad we're getting more from him. When Wilson, the worst president ever, signed the Federal Reserve Act in 1913, few would have described it as following a long tradition. Before the Federal Reserve Act, the American tradition of central banking consisted mainly of the first and second banks. Both of those were short-lived. Congress made the first and second banks to provide banking services to the government. They possessed no sovereign power at all. Unlike modern central banks, the first and second banks in the U.S. did not officially set monetary policy. They did not regulate, hold the reserves of, or act as a lender of last resort for all of the other banks. The first bank of the U.S. and others, and Hamilton defended the first banks precisely because its capabilities would only concern the disposition of its own property and essentially resemble the rules of a private mercantile partnership. Now, the advocates, though, of the Federal Reserve Act did not take themselves to be following in this tradition at all. Instead, they ridiculed it. They described the United States before the Federal Reserve Act as at about the same point that had been reached by Europe at the time of the Medicis, and in Asia at the time of Hammurabi. Paul Warburg, the architect of the Federal Reserve Act and himself a German citizen, began advocating in 1907 for this country to follow the model of the German Reichsbank, which he described as the most perfect organization of its kind. The Reichsbank and other European banks could, unlike American banks, read discount notes, serve as a lender of last resort, adjust the money supply by printing money. In Warburg's view, the system of all other important nations has proved to be excellent, and ours has proved to be defective. So the champion of the Federal Reserve Act in Congress shared this understanding. Senator Nelson Aldrich, the most influential figure in Congress on finance, joined with Warburg to enact the banking legislation. He envisioned a European-type central bank for the U.S. So it's not American, it's European. Aldrich, like Warburg, wanted to transplant the system of one of the great European banks to America in the 1912s. Warburg and Aldrich formulated the Aldrich Plan that would eventually lead to the Federal Reserve Act. They met in 1910 with representatives of three extremely significant New York banks. They formulated a plan for U.S. banking and currency reform that Aldrich would present to Congress, the creature from Jekyll Island. In 1911, Aldrich published the eventual plan, which proposed new reserve banks with capabilities of the European banks. Thomas continues and says, newly elected president called Woodrow Wilson agreed with much of the Aldrich plan, but insisted upon an executive agency that would exercise governmental control over the banking economy, which impacts all of us because we all need money. Wilson, in this respect, was also departing from tradition. He had long believed that, quote, bureaucrats, this is why Wilson sucks, bureaucrats might more effectively govern the country than the American people. He's like a dictator. Bureaucrats might more effectively govern the country than the American people, which is a traitor, really, to the country. Wilson's ideal of government was not of a tripart government limited to the one enshrined in our Constitution, but the German Empire's system of unified administrative power, which he, echoing Warburg, saw as nearly perfected. Great prediction there. Wilson disliked the American system because it ultimately depended on the will of the people, who he thought were selfish, ignorant, timid, and stubborn and foolish. Quote, America, said Wilson, did too much by vote, too little by expert administrative bodies or executive expertness, who are the most incompetent people in the world, all these experts. So when Wilson learned of the plan, he asked for it to be including a novel executive agency to govern banking. Then we got the Federal Reserve Board. The board was the second independent regulatory commission in American history following the Interstate Commerce Commission. Unlike the first and second bank, which possessed no sovereign power at all, the Federal Reserve Board would be a new federal agency with broad powers affecting the entire banking and currency systems. The board would regulate the newly created reserve banks, private commercial banks, and private individuals. We're all beholden to them. We're all governed by them. Warburg saw the board as an expert government body for the state of the future. Wilson signed the Federal Reserve Act into law. He appointed Warburg to be on the board, and he would soon reflect that this was the most radical change. So there's really no tradition in America at all. Great. So the Federal Reserve, though, then authorized and created a bunch of banks, 12 of them. We also got them as private corporations where the government has an interest. They had capabilities like the European banks to read discount notes, serve as a lender of last resort, adjust the money supply, and inflate us into oblivion. They had corporate boards of ordinary powers. They were owned by national banks, private commercial banks, a class of these people, to purchase stock in the reserve banks, all run by the private bankers. So the Federal Reserve Board then, by contrast, was an executive agency. We've got the system and an agency. The board, now called the Board of Governors, writes Clarence Thomas, was the keystone of the act. At its inception, as today, the board had the power to regulate most of the banking economy and has thus always been understood as an agency of the government. The original Federal Reserve Act gave the board a wide range of powers that this court is held to literally be executive. The act granted the board the power to, among other things, impose rules on commercial banks and examine at its discretion the banks, regulate the banks, set rates charged by the banks, fix the check clearing charges, impose penalties on banks. And over the years, Congress has given them even more powers. He says this is far from comprehensive, by the way. They can do basically whatever they want, including the power to issue fines of up to $1 million per day. They can authorize people to act as law enforcement officers. They can regulate non-bank finance companies. We recently heard a challenge on this in a prior case. They regularly issue orders prohibiting private individuals from working for banks. They enforce civil and criminal penalties. And they have 7 members of the board. They serve 14-year terms unless there is a for-cause firing. And in the act, says Thomas, which is the sole basis for the court's decision today, states in the act that each member shall hold office for a term of 14 years unless removed for cause. Then in 22, Biden appointed Lisa Cook, the alleged mortgage fraudster, reappointed her again. Trump came in, said that she got a $203,000 mortgage on a property, indicating that she's going to use Michigan as, quote, her principal residence for at least 1 year. Starting shortly after signing the document. Then 14 days later, she went and got a second mortgage for another $540,000 property, again in Georgia. And in that mortgage, she also said primary residence. Lisa Cook, Lisa. These commitments were relevant because primary residence mortgages get lower interest rates. And for that reason, the government can criminally prosecute people for false claims with penalties of up to 30 years in prison. So Trump removed her. He said, pursuant to my authority under Article 2 of the Constitution, you're hereby removed from your position effective immediately because you're incompetent, you can't fill out your mortgage documents appropriately, or you're a liar. Either way, you're unfit. He explained that there is sufficient reason to believe that you made false statements when you signed these documents attesting that this would be your primary residence. And then 2 friggin' weeks later, you went over and signed another piece of property in Georgia also saying that would be your primary residence. It was inconceivable that you were not aware of your first commitment when you made your second. And it's impossible that you intended to honor both. So either you're financially illiterate and incompetent, in which case you should not be on the Federal Reserve, or you're a fraudster and you should not be on the Federal Reserve. Either way. Yeah, just like Letitia did. Maybe they traded notes. The president explained why she should not remain, saying the board has tremendous responsibility for setting interest rates and regulating the banks. The American people must have confidence that the people overseeing these rates are not deceitful and potentially criminal. Otherwise, we're not going to have confidence in your ability. The conduct that you engaged in is the sort of gross negligence in financial transactions that call into question your competence and your trustworthiness as a regulator. And so therefore, you're gone. So Cook sued Trump and Jerome Powell and the board saying, don't fire me. She said, ma due process. He can't remove me at all. She invoked a bunch of different provisions and wanted to be treated as though she was not removed. The court did that, actually restored her back to her seat against the president's will, saying Trump did not fire them for cause, as Roberts explained in the majority. We know the background there. Trump came to us for a stay, and Clarence Thomas says Trump's going to win. The president's removal did actually comply with the due process clause Officials don't own their public seats. The president's removal likewise complied with the law because he removed her for cause. And because the law does not require a notice and a hearing, it was all valid. Were there any doubt about this? We should not restrict the president's removal power. And he's going to beat each one of her claims. There was no due process situation here. There is no property interest in her position. She says she has a property interest, but that is alien to our entire form of government. He didn't deprive her of anything, therefore, no due process implications. Also, cause. By authorizing the president to remove for cause, Congress gave Cook the weakest available removal protection at all, even weaker than other low standards. Alleged fraud, mortgage fraud, that's cause. It brings into disrepute her entire integrity. Cook's job is to regulate the banking economy, but she is alleged to have made a facially contradictory representation in her own documents, living at two places at the same time. That's inconceivable. That's the president's ability to make that call. This alleged conduct would have been grounds to remove a loan officer at a bank, let alone someone vested with broad powers affecting the entire banking system. So the court rightly does not accept her claim, though, that he lacked cause. You just say it's got to be substantial, reasonable, and just. And he says, yeah, it is, given the fact that she could face 30 years in prison is enough. And so he complied with the law. He gave her notice. Everything that he did was above board. In the Federal Reserve Act, Congress chose not to require notice and hearing. It doesn't say that in the law. It says causes for removal, not procedures for removal. Says it right here. Remove for cause. That's it. Doesn't say remove for cause after a big fat hearing. But the court nonetheless interprets this to mean what they want it to mean. They rely on an interpretive principle and says that it's a settled interpretation of the common law. And so ultimately, the removal provision is not common law. It's written in Congress. The court's interpretation is not based on common law at all. There is nothing in there that says that. And so they invoke various principles that shouldn't apply here. And they wanted the removal power to be broad and unquestioned. The court thus does not even attempt to muster any judicial consensus for this at all, citing a bunch of other prior cases. All of this is built on a single line, which the court repeats 4 times from a prior case. Talking about causes of removal are specified by the Constitution or statute, but not even the underlying logic of this one line of dicta on which the court relies supports its conclusion. It says in the act, no causes of removal are specified. And that means that it's discretionary. Hundreds of laws provide for fixed terms in office, and nobody believes that all of those laws implicitly require notice and hearing. So thus, the court has to rephrase even the one line of dicta to describe a new form of tenure, a term of years limited only by removal for cause. This form of tenure doesn't appear in either of the prior cases, with which a bunch of cites here. And your interpretation is inconsistent with congressional practice that say you can only be removed in Congress. Congress does right. When they want a notice and hearing, they say only upon notice and hearing. They know how to put those words in there. Only removable by notice and hearing. It's not in this act. The law is not written in there. So he doesn't have to do that. And your interpretation of how this works is also inconsistent with the Constitution. Limitation on the ability to remove executive officers are unconstitutional, plain as day. Under our Constitution, the power is vested in a president, just like we saw in Slaughter. Citing Slaughter right there. Thus, we explained in the opinion also released today, the president may remove subordinates at will without cause, without notice, without hearing, so long as they execute executive power. And any statute that limits that is unconstitutional. You guys just wrote that in the other pages today. So it should also apply here. But it's the special exception, the Federal Reserve. The board here unquestionably exercises executive power. Therefore, it must be controlled by the executive. They can promulgate rules. They can use this power to change fees. They have the power to impose penalties. They can examine books. And since Cook restored her position, the board has issued many orders banning people from banking, punishing, criminalizing people. All of that executive. And so since it's executive, the president can remove her. The president invoked the canon of constitutional avoidance in asking this court not to reinterpret the entire act. But the court simply says they don't read it that way. And so the court today upholds the constitutionality of a limitation on the president's ability to remove an executive officer for only the third time in American history. Its constitutional reasoning consists of 2 paragraphs. The court does not dispute that members of the reserve do exercise a lot of executive power. It does not dispute that any person who exercises this power must be freely removable by the president. And it does not dispute that its holding today contravenes those principles by preventing the president from freely removing these people. They also endorse a contradiction. You just said in the prior case that the Constitution vests the whole executive power in a president alone. But the board can exercise executive power independent from presidential control. So the court's reasoning depends entirely on an ahistorical analogy between the first and second banks. The problem for the court is those first and second banks had no executive power, where this board does. And so it's not following our tradition at all. It's not a bank. It's a novel federal agency with broad powers affecting everyone. The founders of our government thought that distinction was significant enough. Although you attempt to imply otherwise, you don't deny that the first and second banks had no executive power. So the president is also likely to succeed on an independent ground that you have to limit your judicial authority. The court today holds that a plaintiff may sue to get their job back, but that intrudes on other prior precedent. She lacks a right of action to enforce her position. Other cases have said this, and the court does not explain how Cook has overcome those other limits. All agree that Cook cannot proceed under the APA, the ordinary right of action, because she doesn't challenge any final agency action. The court does not accept her argument that she has a non-statutory ultra-virus claim either. And so all of her claims to get her job back, like the specific form of relief, are not in the rules. Even if she did have a right of action, our prior precedents would foreclose that. You issued an equitable remedy. You tried to balance the wrong by shoving her back into her office. But we have long said courts of equity have no jurisdiction over public officers. And so under our precedent, the lower courts lacked authority to shove her back in her office. Now you're reading categorical statements in our precedents to apply only to final injunctive relief, not to interim relief. And this is all new. Newfound distinction makes no sense. And you shouldn't have put her back in there. Today's decision is an unprecedented incursion on the executive branch. Neither the parties nor the court can point to a single time in American history that this court has upheld an injunction against the president's removal of an executive officer. In the 237-year history of our Constitution, we have never done that. And finally, the balance of the harms also favors the President Trump. The government faces greater risk of harm in having her in her position than not. We found that in Trump versus Wilcox, Trump versus Boyle, Trump versus Slaughter. The court offers many policy arguments for independent Federal Reserve. And for example, Kavanaugh says it's going to prevent political upheaval. It's going to prevent turmoil in the world economy. It's going to promote the efficacy of monetary policy. And as the court tells it, the Board of Governors of the Federal Reserve System has for the past century served to provide the American people, he's quoting, with stable prices, maximum employment, and we don't have any ruinous financial panics, amazing, and a banking system that's free from suspicion. So you guys keep saying that. The court credits this century of supposed success to the board's independence from the president, and in turn, the voters, the common people who play the antagonist in the court's account of the 19th century. But he says many do not share your rosy appraisal of the past century. No, we don't. But if the court prefers an independent Federal Reserve, then its issue is not with the president, but with the Constitution. Regardless of whether unaccountable executive officers like Cook would better govern the economy, the framers rejected such the promised land of technocratic governance. They instead chose a government by the people. As a court, our duty is not to second guess that decision, but to uphold it. And so, therefore, I respectfully dissent from the denial of the stay of application. Man, I was hoping that Thomas would go into this a little bit more. There's a big list of panics and problems and inflation and good employment, low employment, lots of suspicions and ruinous financial moments that we've gone through. And that's why we need the Federal Reserve. For what? What have they done? What's our national debt again? How much is our money being inflated over our years, my entire life? What is the cost of everything? Why is it going up? Let's see what Alito has to say. He says, this case presents many thorny legal questions. What is the substance of for cause? What does that mean? Do governors have an implied right of action to sue? What degree of judicial review, if any, exists? What showing of irreparable injury can require shoving a fired personnel position back in? What does the president's social media post convey? May courts, consistent with Article 2 and Article 3, countermand the president's removal? Can the president appeal an injunction that no enjoined party challenges? Alito says, some of these questions present issues of first impression, and many of them lack obvious answers. More important, lower courts in this case have passed on the very issues that are before us. Now, what is before us is simply an application for a stay, whether it should have been granted or denied. The lawsuit is new. But rather than resolving several challenging and underdeveloped issues, I would decide this application solely on two issues. Very simple. A summary of this case history illustrates the imprudence of how this court has handled this. The president purported to remove Lisa Cook when she was fired. After 12 days, one round of temporary restraining order briefing and a single hearing, the lower court then issued an injunction and shoved her back in. The court rested its order on two grounds, saying there was no cause to remove her because it happened before she got in office, and the president violated her due process rights. When that all came to us, this litigation was 21 days old. There had only been two rounds of abbreviated briefing, and the record doesn't even contain copies of her mortgage fraud. So, of course, parties may appropriately seek stays in early litigation, and no court, though, should sit on its hands when that is appropriate. But this does not mean that the court must reach out to opine on each issue that could conceivably pop up in the future. Here, the incipiency of this case and the complexity of the issues that it presents counseled in favor of a light touch by this court. We should have resolved this shortly when the president submitted it. We could have issued a statement explaining our decision. Would have been good. But had we adhered to this well-born path and decided this back in October, then we could have relitigated this case. By now, they might have granted summary relief for one of these parties, and it could have come back to us before this 280 days that have now elapsed. Instead, this court departed from normal practice. We deferred a lot of these issues, held oral arguments in January, then we're making these convoluted decisions way after the fact. So consider Trump's likelihood of success on this. Is removal for cause? Is it limited to in-office conduct? Like, that's the standard that they set. Is that really true? And whether the attempt was a due process violation. He says the courts were incorrect on those two very simple issues. As the majority and even Thomas apparently agree, they made a mistake. They erred in saying that for cause only means events while in office. The majority did find that. He said past and present. And Thomas, as Katzis, the dissent in the Court of Appeal said, Cook also lacks a private property interest. So how could it be due process? Because the courts could have resolved these issues quickly and they did it incorrectly, I would say the president has shown a strong likelihood that he's going to win and grant the stay so that she could be fired. Therefore, I think a stay is warranted here. We didn't need to turn this into a big spectacle. Just needed to decide those two issues. The stay reversed. a stay is therefore warranted here, a stay of the limitation of the firing. Okay, so stay the decision to injunct the president against the firing. So therefore, I respectfully dissent from Judge Alito, and then a little short one from Barrett. From Amy Coney. The court chooses to answer a series of difficult merits questions, most of which were not addressed by the lower court below, just agreeing with Alito. What kind of cause must be before? What statute gives her due process? If so, if there is due process, what kind? Can she claim her removal and challenge it by asserting an ultra virus claim? May a court issue a preliminary injunction to keep her in office? And then the biggest question, is the removal restriction in the Federal Reserve Act constitutional? All these questions are complicated and in a league of their own. And unlike the other issues, the constitutional status of the Federal Reserve is entirely outside the scope of this case. The government expressly waived any constitutional challenge, so the parties didn't brief it. And the lower courts approached this case from the start on the assumption that the removal restriction is consistent with Article 2. Normally, we don't jump ahead of ourselves here, but we did. And the court raised and then settled the constitutional issue. They raised this. They said, oh, first and second banks mean we can do this. Nobody brought those up. It's about removal and due process. But let's talk about the first and second banks. Okay. So even assuming the court is right on the merits, the issue warrants much more than this. As Thomas points out, the differences between the Federal Reserve and our early national banks are more significant than the majority let on. But they love the bank. The bank is everything. And the court's holding is in serious tension today, thank you, with Trump versus Slaughter, which we just decided 5 minutes ago. Slaughter announces a categorical rule. When an agency executes a congressional mandate against private parties, it exercises executive power, must be subject to the plenary power of the president. No ifs, ands, or quasis about it. Yet here, the court claims a special exception because of history and based on the Federal Reserve's role in setting monetary policy. And Kavanaugh's really concerned about the economic instability. How can history support both a categorical rule and a carve-out? Great question, Amy. Do all the Federal Reserve's existing regulatory powers have the requisite connection in monetary policy? Are they all grandfathered in? Are they attenuated? Do they get additional powers? And is the Federal Reserve unique, or might history sanction other exceptions? The court doesn't answer those questions. But for the present purposes, the most significant problem with all of this, not to mention many others covered in its opinion, is that the court decides this at all. While a modest approach would have been appropriate, the court chooses to go big because the three libs got them on. Its opinion sets precedent on a series of important issues with implications that extend well beyond this case. Barrett says, I agree with Alito that the court should have limited itself to the narrow issues. Addressing these errors would have permitted this litigation to proceed. Lower courts could have taken the first cut at this. Had the court declined to go further, may have never even come up. For example, if the president ultimately satisfied the Federal Reserve Act, the court would have never even needed to address an ultra-virus claim. But putting aside my difficulties with the scope of this thing, there is a disconnect between its holding and its disposition line. The court does not rule out mortgage fraud as sufficient cause for removal. Instead, it denies a stay on the narrow ground that there hasn't been enough process. The president remains free to, quote, try again, as the court says, so long as he goes through a proper notice and opportunity period. Great. So like invite her over for a 15-minute meeting. Done. You're done. Now you're fired. Get out. But if the court wanted to leave the president in that position, it should not have denied the stay. Recall that the district court held that her alleged mortgage fraud as pre-office conduct does not constitute cause for removal, saying only permissible cause is in office while you're in office. So you could go murder 100 people before they find out, oh, you're a serial killer. Well, you didn't kill anybody while you're in office, though, so that's fine. So it entered a preliminary injunction stopping her from being fired and saying that it entered a preliminary injunction banning the Board of Governors from effectuating in any manner her removal on the basis of the grounds in the president's letter. So you can't remove her for any reason that Trump said, even though the majority just said that's a reason to remove her. The president's letter clearly stated those grounds. We think you committed mortgage fraud and you're a liar. So as it stands now, then, the president has no way to remove her, even for mortgage fraud. That is true. Even if he gives Cook a full-blown trial, gives her all the process in the world, he's still prevented right now. And satisfied your new invented substantial threshold for cause. So to get around this problem, the court then adopts an implausibly narrow reading of the injunction. It interprets it to forbid the implementation of Trump's letter, but not to forbid him from trying again. In other words, the injunction stops Trump from firing her by that letter, but not firing her for mortgage fraud. But that is not simply what the injunction says. It forbids Cook's removal, period, on anything stated in the letter. And the DC's order denying that stay is broad and leaves the injunction in place. So we have repeatedly, says Amy Coney Barrett, repeatedly found that the president suffers irreparable harm when he can't fire subordinates. We found it in Trump versus Wilcox. We found it in Trump versus Boyle. And so in my view, that harm is somewhat lessened here because the government has conceded that the president cannot remove them for simple policy reasons. But still, the lower court order blocks him from removing her even for mortgage fraud. And that is so even if he satisfies the requirements. And so under our precedent, that significant interference with the president's removal authority is an irreparable harm. And so for these reasons, I respectfully dissent from the denial of the stay application. And so what a disaster of a decision this was. Clarence Thomas educated us on some differences and distinctions between the first and second banks and the Federal Reserve. Kavanaugh comes out in his concurrence saying, well, we have to protect the bank because if we don't, society is going to collapse and crumble. And the economies of the world will come crashing down. But the majority basically is propping up the court or propping up the bank, creating a strong foundation to say any future challenges are going to fail because we have a long history of having national banks in America. And so we can continue to have this separate branch of government. It's literally an independent agency, but because it kind of resembles other prior independent agencies, will allow it to exist, even though 5 minutes ago in the Slaughter case, that is the literal exact same argument that the dissenting libs made. They said, we've been doing Humphrey's Executor for 150 years. We've had a history and tradition of independent agencies. It's their same argument. In this case, it's just because of the bank. So once again, it is, I think, John Roberts, who is an institutionalist more than he is a conservative textualist or originalist, who is trying to thread the needle and not have the court be responsible for eliminating the Federal Reserve. It's too big of a bite for him to take. So he's joining with the leftists, which is really a disaster because the Federal Reserve likes to pump themselves up and nobody wants uncertainty. And so at least, the devil you know is better than the devil you don't, as they say. So, okay, we've got the Federal Reserve, but as far as I can tell, we've had many booms and busts. We've had many panics. We've had many bank failures, all propped up. We've had gobs of money printed during the Great Recession. Remember, the Federal Reserve was going to prevent the next Great Depression. And then we had all of the scares over dot-com bubbles, all these bubbles, housing bubbles, all of it just continues to fail. And they just print and print and print, and our dollar gets diminished and diminished and diminished. And who is getting richer? Well, the 1%, the people running the banks, in large part. So another 5-4. Roberts doesn't want to bite this off, just like he did with Obamacare. He does not want to go in and invalidate Barack Obama's new signature bill because it might make the court look biased and partisan. He doesn't want to take out the Federal Reserve, so instead he joins with the libs, and Kavanaugh, very disappointing on that. He writes a concurrence to say, well, I'm scared. I'm basically scared. We don't care. Be scared, but follow the Constitution. Thomas is exactly right. This is an independent agency. It's not created by a constitutional amendment like they did with the income tax. It was passed by Congress, and it creates a board just like the FTC, just like the SEC, just like these other entities that governs itself and governs all of us, and they're not accountable to the people at all. So the bankers win. Thanks to Ketanji, Sotomayor, Kagan, Kavanaugh, and John Roberts. 5-4 decision. And we'll see what happens when it goes back down. Lisa Cook can still be fired. The standard is not her standard. The standard is not only for action after I got into office. And it's not like an extreme amount of cause. It's a pretty low stat amount of cause. Prior bad acts can count. Trump needs to give her a little notice in hearing. Like I said, 5 minutes, bring her in the Oval Office. Hi, Lisa, you're fired. What do you have to say for yourself? Denied. Get out. That's process. And if they want to do a little bit more than that, it'll shore that up. But otherwise, we'll see what ultimately happens. It'll go back down. But the takeaway from this decision is that they're really propping up the federal court. 111-year history. Not really. It's European. It's from the Germans. And they're inflating their money too. So we'll keep our eye on this case as it goes back down. But Lisa Cook survives for now. Stays in her position until the lower courts flesh the rest of this out and apply it to her specific facts. But even from the court standard, I think there's a strong nexus there that she was committing a federal crime related literally to her work product, which is setting interest rates. And so the nexus is strong. Hopefully she's gone, and we'll be back here to cover that too. Thanks for joining and subscribing as we do. All right, now let's turn our attention to another crappy decision that dropped. What a joke this one is. And this one delivered to us courtesy of Amy Coney Barrett. We're just confirming it's 5-4. Yeah. Oh, gosh. What a stupid joke. This day sucks. All right, so let's talk about this one from the Supreme Court. Supreme Court hands a victory to the leftists who like to continue to count ballots way after the election is already over. You see, it's a 5-4 matter, and it was given to us courtesy of Amy Coney Barrett. It's Amy and John Roberts who are joining in with Sotomayor, Kagan, and Jackson. The question before us is, can Mississippi continue to count ballots after they come in after Election Day? 5 days after the election is over, they're going to cabinet and say, oh, it's only postmarked. So if it's postmarked before the election day, then they can continue to come in and be counted. But as we've covered here many times over, postmarks are like suggestions. They're not infallible. Many pieces of mail are not even postmarked at all. They go through the postal system without actually getting stamped, and others may or may not be fraudulent. We also have the question about people collecting ballots and whether they can collect the ballots and say, I picked them up on this day, and I'm now delivering them to you. Will those be counted, yes or no? Of course, they will be counted because they're ballots, and nobody wants to disenfranchise anybody. So Amy came down. We've got dissents from Judge Alito, Thomas, and Gorsuch joining in on that one. Kavanaugh also joining in as to most of it, but not on a couple of parts. So 5-4, the libs, I would say, win this one because they love to count late day ballots. Election is over. They just go harvest them and keep putting them up on the board. So here's what we got. From Amy Coney Barrett. 3 federal laws set the day for the election of reps, senators, and president. A Mississippi law permits the counting of absentee ballots, where a ton of fraud comes in, that are postmarked by election day, which is a suggestion, but received up to 5 days later to count. Election's over. You got your mail in, that day of the election, takes 5 days to get there, comes in on day 5, it counts. We must decide whether the federal election laws preempt Mississippi's laws. So does a federal election day beat Mississippi's day +5? She says they do not. So Mississippi's law stands. Wild. So the Constitution's election clause says that state legislatures can prescribe the time, place, and manner of elections. Congress may override these choices if they want. Now, by default, however, responsibility for the mechanics of elections belongs to the states. As Alexander Hamilton put it, the Constitution lodges power over elections in legislatures primarily and in Congress ultimately. Now, the Constitution system for presidential elections is also similar. States may direct the manner of appointing electors for president and VP, but Congress may determine the time of choosing of the electors and the day on which they shall give their votes. Now, initially, Congress allowed states significant leeway with respect to the timing. States had a 34-day window to appoint electors and exercise total control over the timing of federal elections. As soon became clear, though, this scheme was not the founding generation's finest. Weird. So that means if you have a 34-day window, what happens? Oh, fraud, or at least allegations of it, ran rampant because states could hold elections on different days. Voters could travel across the country, casting ballots in multiple states. Fraud. So in 1845, Congress enacted the first election day statute, setting presidential elections for Tuesday after the first Monday in November. As of January 23rd, 1845, good. Allegations of fraud, though, continue to plague the election of representatives. That still took place on different days in different states. Having one election day for the president and another for reps was also burdensome because citizens were forced to turn out to the polls on two different election days. Plus, the results in states with early elections could influence voting in states that lagged behind. So in 1872, Congress intervened again because of the fraud. So mandating that the election of representatives also take place on a single day, same Tuesday as the presidential day. After the ratification of the 17th Amendment, also a joke, Congress then required senators to be elected on the same day as the reps. Got to get rid of that one in the 16th too. Today, each of the three election day statutes sets the day for the election on a Tuesday. Now, in our nation's early years, says Amy, voters had to cast their ballots in person in the district where they lived. Brilliant. Elections were lively public events marked not only by continuous electioneering and political arguments, but picnics, drinking, boisterous celebration, which we should return to. Public assembly was not just a matter of merriment, it also helped ensure that only those qualified to vote did. Ballots were cast in the company of neighbors. People could see what was going on. For instance, under the Pennsylvania Constitution, a voter had to vote in an appropriate election in order that his neighbors might be at hand to establish his right to vote if it were challenged, or to challenge it if it were doubtful. This is why we want it on election day, and we want it to be everyone. Things started to change during the Civil War, though. Some states allowed soldiers to vote from afar by absentee. Access to absentee voting expanded throughout the 20th century, and today every state lets at least some residents vote absentee. In fact, federal law requires states to permit absentee voting in certain circumstances. Now, due dates for these ballots have shifted over time. During the Civil War, we're going to get a lot of Civil War analogies. We're not in a civil war. Not yet. But you keep this crap up, maybe we will be. So during the Civil War, states that allowed absentee voting imposed an election day deadline for ballot receipt. They could figure it out even then. During a literal civil war, you're a soldier, you want to vote absentee, you still got to get it in on time. I know, but I'm on the front lines fighting the South. We don't care. Just get it in. But during World War I, states began counting absentee ballots after Election Day. World War I, also the time around Woodrow Wilson when they wrecked the rest of the country. Today, roughly 30 states count at least some absentee ballots mailed by Election Day but received afterward. 30 states with late counts. Mississippi is one of them. In Mississippi, certain residents, like college students away from home and senior citizens, college kids can't figure out how to get their mail in. Senior citizens also. Sorry, I got confused. These voters may dispatch their mail by mail or, look at this. This is what I'm talking about. Common carrier, okay? It's not, in Mississippi, it's not just mail, all right? It's common carrier. So stuff may not even go through the mail on this. So as long as it's postmarked by election day, common carrier doesn't mean it's going through the postal service. All absentee ballots must be postmarked on or before the date of the election and received by the registrar no more than 5 business days after the election. RNC sued Mississippi for this crap law. According to the plaintiffs, the RNC, the election day statutes use the word election to refer to 2 acts, ballot casting and ballot receipt. So by setting the day for the election, they say these statutes set the deadline for both. You can start the election and it's over. The district court consolidated these cases and we're here. Now the question is pretty narrow here. It's about timing, says Amy. They don't challenge the manner in which Mississippi carries out the elections. They don't, for example, challenge the general practice of absentee voting, nor do they challenge the use of the Postal Service or a common carrier that's not the Postal Service, somebody vouching for when they got the ballot to transmit the ballots. Although the election day laws refer to a particular day, they do not contend that everything must occur on that day. They do not object to early voting or dispute that officials may count votes and certify a winner after election day. Okay, so you can get all the ballots, receive all the ballots by election day, but count them the day after and decide the next day. She's, oh, is that okay? Yeah, that's okay. And so you can count early. Yeah, you can vote early. And that's not a contradiction to election day. She says, also, this case is not about the Constitution. We don't consider the scope of Congress's authority to regulate this. The only question before us is whether counting ballots postmarked by election day, but received up to 5 days later, violate the federal laws. She says, the federal laws do not preempt Mississippi, so Mississippi can do whatever it wants. The defining element of an election, the term used in all 3 laws at the federal level, has always been the electorate's choice of a candidate. As a related statute, UOCAVA confirms that while federal law dictates when ballots must be cast, state law dictates by when they must be received. And as we've said before, the federal laws simply regulate the timing of the election. The statute governing presidential elections says electors shall be appointed on election day, the next Tuesday in November. The statute governing House says very much the same thing, and so on. So by setting the day for election, these statutes set the day when the electorate must make its choice. So choice, not receipt. It is a fundamental canon that words generally should be interpreted according to their ordinary meaning. The election day laws were enacted across almost 2 centuries. At all times, election was meant to understood the act of choosing the person. You choose, that is election day. We've also defined election as the expression of the choice. Bunch of quotes there. And so the choice is made when voting is complete, not when ballots are received. The most recent amendment to the election day law bears this out. In 22, Congress inserted the phrase election day into the law, said it's a specific Tuesday. It created an exception when states modify the period of voting. So voting versus election. In response to certain force majeure events, the term election day shall include the modified period of voting. So voting can be early voting, but then the election is not election day. It's the time of having to make your choice. Really, it's not even about the day. It's about choosing. Then those ballots can go in and they can collect them after the fact. That Congress defined election day with reference to voting indicates that voting is the act governed by the law. Now, as related, UOCAVA reinforces this point. It is the most rudimentary rule of statutory interpretation that courts do not interpret laws in isolation. We have to look at them in context. And UOCAVA, the overseas voters, many of whom I'm all for, military and military contractors and people in service of the U.S. government voting overseas. But if you're some Rosie O'Donnell or somebody and you're living over in Ireland, why should you vote in American elections? If you don't reside in your state, if you move from Arizona to Washington, D.C., and you reside in D.C., you don't get to go vote in Arizona absentee. So if you leave Arizona and go to Europe or go to Ireland or wherever, why do you get to vote? And Uokava confirms that while Congress has set the date by which absentee, and by the way, I can still vote for president and the other things, but not a senator. So, and anyways, Uokava requires states to permit absent military and overseas voters to vote, and they presuppose that ballot receipt is a matter of state law under federal law. For example, it specifies that a federal absentee ballot shall not be valid if the state provides an absentee ballot at least 60 days before the deadline. Also talks about some rules for military voters. And so this is all consistent. If the election day laws established a nationwide ballot receipt deadline, these references to other state ballot receipt deadlines would make little sense. So federal laws can allow the receipt to come in later as long as the election choice is made by election day. Now, finally, this interpretation is consistent with the Constitution. Although most voting in our country's early days occurred in person, which is what we should go back to, making casting and receipt simultaneous, that was not true of the Electoral College. For that, the Constitution establishes a system somewhat analogous to absentee voting. Presidential electors shall meet in their states, vote by ballot, transmit those to the state of the government. Yeah, it's because we didn't have cars, It took a long time to take the votes from a state into DC. We didn't have airplanes, okay? The Constitution requires the day on which to be the same throughout the United States, but it says nothing about the day for receipt. So the Constitution envisions a system in which receipt is divorced from voting and sets a uniform day as voting, leaving the receipt to happen later on. So in sum, the statutes require the choice to be made on election day. That occurs so long as election day is the deadline for the individuals to vote, like in Mississippi. But the laws do not set a receipt deadline, so they do not prevent Mississippi from counting ballots postmarked before election day, but who receive it after. Now, I'm curious to see what these dissents say, because she has not even, so far as we've seen here, touched the common carrier. Plaintiffs, echoed by the dissent, accept that the meaning of election is choice, but they still argue that the laws, speaking only of choice, set a deadline for receipt. But she says they don't have any support for this, and historical practice is not dispositive. And so when it comes to the ordinary word that is used, election, it's not a dispute. It's making a choice. But the dissent and others say that choice requires more than ballot casting, and it needs to be authoritative. And in any event, we do not know who won when all the ballots are received. Many other acts must occur first. Voter qualifications need to be adjudicated and more. So you may not even know if it's a close election. You may have to do signature checks and all the things. So she's saying, so it doesn't matter if they come in after election day because we're still doing other work on it anyways. And while one might dismiss certain timing as a byproduct of in-person voting, when some states authorized soldiers to vote by mail, ballot casting and receipt were no longer simultaneous. So states could have allowed a grace period for them, even though they didn't. All the states, even during the Civil War, got them in on time. Instead, plaintiffs say ballots traveling through the war-torn country were not counted unless they actually made it in on time. Why would states be so exacting if federal law did not demand that? Now, plaintiffs admit they cannot precisely tie this practice into the text of the current law, and that is a delicate understatement, says Amy. Plaintiffs' theory is that if the relevant states could have changed the rules, they would have. But despite this deep history, there is no evidence of that happening. So she's now addressing the dissent. We're going to read the dissent and see what they say. So that's coming up. But in any event, their interpretation of today's laws is at odds with Uokava that says states retain the power to set the deadline. And plaintiffs and the U.S. cannot even agree amongst themselves about how reconciliation would work if ballots come in. And all this is Amy Coney Barrett. She then is talking about precedent. They say a prior case says election day. In Foster, we considered Louisiana's systems for open primaries. And while this system was in place, over 80% of the contested elections ended as a matter of law with an open primary. Again, going into the dissent, which we're going to read. And finally, they assert that requiring ballots to be received by Election Day protects election integrity and increases voter confidence. And as we have said time and again, however, policy arguments are properly directed to the legislatures, not to us. So you don't like this late collection, go talk to Mississippi. The question today is not about ballots being received on Election Day. The question is about U.S. code. And regardless of the definition of election, their definition would do little to address these concerns. Plaintiffs and the dissent argue that if we uphold Mississippi's law, states could put party bosses, ballot harvesters, Uber drivers in charge of collecting ballots. But this would also be permissible under their interpretation, so long as the ballots are delivered by Election Day, missing the point. As the dissent concedes, only the timing, statutes regulate only the timing, not their manner. Yeah. Amy, the problem is Uber drivers are not going to be postmarking the ballots. That's the problem. Plaintiffs also stress that the Mississippi law may give rise to the appearance of fraud after votes flip on Election Day, just like what happened with Spencer Pratt. But even under their interpretation, last-minute flips are possible anyways. And so election fraud and its appearance are serious issues. Like other such issues, however, they must be addressed through the democratic process. The Election Day laws are proof of concept. When voting on different days in different states sparked fraud, Congress set a national deadline. If varied deadlines for ballot receipt similarly call for a national solution, then Congress can fix that too. Now, there is one late-breaking matter, she says. For the first time, plaintiffs argue the Mississippi system violates the Postal Service, saying a voter who regrets her choice after mailing it in can nullify her vote, recall it from the Postal Service, and then resubmit it. Now, they have never independently challenged this aspect before. Ballot recall was not the basis for this litigation. Even now, they say that might be one reason for a new contest. She says two principles are important here. First, post-election day receipt considered on its own does not conflict with the election laws. Second, state law is preempted by the federal election day laws, only so as far as the conflict extends. And so, coming to a long conclusion, the framers recognize the difficulty of crafting election laws applicable to every probable change in the situation throughout the country. So instead of constitutionalizing election law, they decided a discretionary power over elections needed to be lodged somewhere. Not in the court. The laws say nothing about receipt. We cannot add the words. And so the judgment is reversed. The case is remanded. And in Mississippi, they can collect ballots up to 5 days after the fact. Now, she talked about the Uber drivers. She says you could do that. But how are they going to postmark the ballots other than just vouching for it? So here's what Alito has to say. And usually he's fire on things like this. He's joined by Thomas, Gorsuch, and Kavanaugh to make up the four. So the four reds dissenting here. Alito writes, federal law designates the Tuesday next after the first Monday as Election Day. As the court explains, an election is the expression of the electorate's choice. But because the electorate is a collective body consisting of many individuals, the way in which it expresses its choice is less straightforward than it would be if it was only one person. If the electorate were an individual, it could issue a document declaring that specified men and women were selected to fill the offices. But because the electorate is a body, it cannot express its selections in that way. Instead, its choices are embodied in the collection of ballots cast by the individuals who make up the electorate. So taken all together, this collection is the equivalent of a single document declaring the winner of each race. This expression of the electorate's choices is conveyed to the responsible election officials when the collection of the ballots is completed. And then at that point, the electorate authoritatively expresses its choices as a body. And what the Election Day laws demand is that the authoritative choice be made on Election Day. If ballots received after Election Day are added to the full set of ballots that dictate the outcome, the choice does not occur on Election Day. The federal Election Day laws are violated. And so in this case, we must apply this interpretation of federal election day laws to Mississippi that requires them to take ballots 5 days after. The acceptance of these late ballots effectively postpones the date on which the choice can be made, and federal law precludes that postponement. So Amy Coney Barrett says everybody can make a choice by election day, and they can come in and the choice can be made after. Alito is saying, no, you can make your choice. The choice is made of the election on election day as a nation. We have some unity. So for this reason, I would affirm the decision that said Mississippi violated federal law because the court reverses that decision based on a flawed argument. I dissent. He explains, for more than 100 years, federal law has designated an election day under U.S. code and long provided that electors of the president shall be appointed on that day as well. And because the appointment of electors in each state is now decided by popular vote, voters express their preferences for that person on the same day. Mississippi law, though, bypasses that, provides that voters may submit these ballots to election officials by mail or common carrier to be counted and must be postmarked by that day. And officials must then receive them no later than 5 days. And if they're after the 5 days, they are not counted. So the question we must decide is whether the provision allowing receipt is consistent with law. Now, as noted, says Alito, the federal election day laws provide that elections for federal office must occur on a specified date. May seem like a simple rule, but we have to explain it. The first is the meaning of the term election. The majority says election means an expression of the electorate's choice. Alito says, I agree. The second issue is the identification of the acts that constitutes the expression of the choice. And those acts are the final submission and the collection of the ballots. Therefore, they must occur on election day. That is what the statutes required when all voting occurred in person, and the same requirement applies today. Back when all voting occurred in person, the voters went to the polls on that day. They then completed the ballots and handed them in. When the polls closed, the officials had a fixed collection of ballots, all taken together. Those ballots, the collection as a whole, was the electorate's collective choice. That expression of the choice having been made, the election day laws did not require that anything more be done before midnight. Of course, no one could know the outcome until those ballots were examined and the valid ballots were counted, but it was not necessary for those steps to be finished on election day because the choice had already been authoritatively expressed. Now, today, not all voting occurs in person on election day. Both voting by mail and early voting have become popular, and respondents do not dispute the lawfulness of these practices, nor do I. But acceptance of these practices cannot change the fact that under federal law, the choice of the collective electorate must still be made on the day. That requirement is met in a jurisdiction with mail-in voting when the completion of all of the ballots is done. That is what took place when all voting was done in person, and compliance with the laws demands the same. Now, the court disagrees and concludes that the election day laws merely require that each person cast it before election day. But if that is all that the election day law requires, there is no sense in which the electorate as a whole can be seen making its choice on election day. Rather, the electorate's choice could be made piecemeal over an extended period prior to election day, and that prospect is blatantly contrary to what the laws demand. Now, election day is a date, not a span of multiple days. The laws require the election occur on that date. Under the Mississippi law, however, the collection of ballots continues for 5 days after. So therefore, the election is not held until the end of that period. Because federal law requires the election to occur on election day, it preempts Mississippi. Amy went into dictionaries. She looked at these dictionaries, and contemporary state laws also provided an election was not finished or closed until polls closed, and other decisions corroborate this interpretation. When statutes pegged certain legal consequences to an election or voting, courts held that ballot receipt triggered the consequences. One case, Pennsylvania court held that a 10-day limitation period for contesting the outcome of a race began running once officials closed the polls on election night. Polls closed, elections over. Similarly, when the Supreme Court of Alabama resolved the charge that a defendant illegally voted, the court held the defendant could not be found liable unless there was evidence that his ballot had been received by a poll worker and placed in the ballot box. And so a 19th century law requires an election to occur on a particular day. That means same applies to the states. And 2 centuries of historical practice confirms this. It means all received by the date. From this country's founding until the 20th century, election day ballot collection was near uniform. Before the Civil War, nearly all voting occurred in person on election day. The practice did not even falter during the Civil War. Soldiers hundreds of miles from their polling places, election day still meant ballot collection day. States took different approaches to ensure that they could vote while away. Some states allowed them to mail their ballots back. Some used proxies to take them back. Others sent commissioners or soldiers to distribute absentee ballots and deliver them. Third group tasked military officers with doing other things. But the point is, regardless of the method that the state used, each state continued to mandate everyone needs to be back home by election day. Now, the practice of collecting all ballots persisted into the 20th century by the election day. To be sure, there were some departures from this norm in the years after Congress enacted the final election day law. During the World Wars, Congress and at least other 9 states allowed ballots to come in after election day in certain situations. But the practice returned back to the margins after the wars. By 1977, a DOD listed only 2 states as still allowing ballots to arrive after the election is over. So it was very short-lived. Those are outliers. And likewise, although post-election day deadlines have become more widespread in the last 5 decades, these developments post-date the last election day law by over 50 years. And so in sum, from the nation's founding until the last few decades, a period that spans all 3 election day laws, election day meant completing collection on the day. But the majority brushes this all aside. They say we haven't given them enough evidence. For all we know, says Alito, the majority says the states might have insisted on receiving ballots by election day for their own reasons. He says Amy's argument withers on examination. The states were acutely aware of the laws, and they abandoned practices that they had previously used and preferred to comply with them. As the majority notes, before 1845, states had total control over their elections. They had different dates, but after 1845, they abandoned those practices. And it boils down to this from the majority's perspective. States complied with what they understood the laws to require. They did not believe those laws required ballots to come in by election day. But they nevertheless eschewed the freedom that they had asserted before then, and then were just voluntarily complying. They did all of that, they speculate, because it just may not have occurred to them. Okay, says Alito. To say that this is the most likely explanation of the state's thought process would be a delicately put understatement. The notion that extending receipt deadlines for soldier might not actually have crossed their brains because they're not as smart as Amy is hard to even take seriously. States valued their citizens' right to vote and their voices of their soldiers. They surely knew it would take time for ballots to go back, and they made it happen. They knew how to extend deadlines, citing a bunch of laws. And so given these examples, it strains credulity to suggest that the thought of extending deadlines simply never occurred to them. But in any event, the majority does not explain what sort of evidence that we would need to offer to tie this to election day. Readers are left guessing what kind of evidence would suffice. Regardless, the majority places the burden on the wrong side, saying you separately worry that using historical practice to interpret election might trap states, but the policy is consistent and it's compelled by text, context, and history. And your worries are exaggerated. All agree that the relevant provision of the election day laws regulate only the time of the election. So in short, although the majority attempts to fend off 2 centuries of American practice, the takeaway from this is clear. When Congress enacted the 3 election day laws, having the election on a particular date meant ballots would be collected by that date. So having considered all of this, let's talk about precedent. He talks about Montana, and he says, the court said in that case, the ballot was not cast until officials received it. And because law mandated a day, the court held that post-election day deadlines were preempted, and you got to get them in by the day. Citing some other precedent, another one in Foster versus Love. But the majority is now not even following the court's own precedent. Part 3. Now, the majority's remaining arguments are also insufficient. They note that several provisions of UOCAVA allow something like this. They invoke interpretive canon to favor reading statutes in a way that accommodates later enactments of law. But their argument falters. In any statutory interpretation case, the goal of the court is to determine what the statute meant at the time it became law. And her argument is not met here. As the majority says, UOCAVA applies to primaries, which are not the subject of election day laws at all. And so for those elections, state law supplies the only ballot receipt deadline. So UOCAVA cross-references to them, makes perfect sense when it comes to deadlines. And then contends that this interpretation does not work because UOCAVA does not distinguish between the kinds of elections. Separately saying that early voting might be called into question, right? If you have an election day, does that mean that all early voting is bad? Again, to reiterate, says Alito, it is the decision of the electorate, not the vote, that constitutes the election. No matter when a state receives a voter's individual ballots, early is okay. The electorate's choice is not made until all the ballots in the set have been cast and collected. So long as that occurs on election day, we're good. But now, this decision, not only, says Alito, is your decision inconsistent with statutory text, can't even read, legal context and historical practice and precedent in court, it also threatens to produce lamentable consequences. The majority's holding spawns a slurry of troubling election law questions and risks further undermining Americans' confidence in election integrity. They hold that a state complies with federal law if they count ballots 5 days after they get them. But this simple holding obfuscates the many unsettling questions that the majority's position entails. For instance, do the federal election day laws impose any ballot receipt deadlines at all? Mississippi counts ballots that come in 5 days later, but nothing in the opinion mandates that it's 5 days. In fact, some states will count mail-in ballots as late as 21 days. Washington. If the election is complete when voters fail out their ballots and send them on in their way, may states eliminate ballot receipt deadlines entirely? Why not? It appears that the only federal backstops for ballot receipt are the date when newly elected reps and senators must report in for their jobs. Now, here's this. Thank you, Alito. Would it suffice under federal law if a state authorized voters to tender their ballots to any third party by election day, such that there is no postmark? Mississippi counts late arriving ballots only if they are sent using a postal service or common carrier. But nothing in the law gives those entities special treatment. Could a state therefore count late arriving ballots if they are delivered by some other intermediary? How about a relative of the voter? What if a neighbor says, I'll drop it off for you? What if an Uber driver agrees to serve as a courier? Uber courier right there. A ballot harvester affiliated with a political party or interest group. How about that? Many states use something other than a ballot's postmark to determine when someone voted. May they? Can they do that? Mississippi requires that an absentee ballot be postmarked on or before Election Day, but other states don't require that at all. California Election Code says relying on the date that a voter signed the ballot envelope. Okay, that's what I'm talking about. California, they don't care about the postmark. They care about the date you signed it. You just sign it. Oh, yeah, I got it in. Do those state laws comply with the election laws? What happens if a voter deposits a ballot in a U.S. mailbox on Election Day, but the pickup already happened for that day, and they actually get it picked up the following day? What happens if a courier offers a recall service? The majority's rule apparently rests on the notion that a voter has made a final selection once the voter tenders the ballot, but the Postal Service allows customers to recall mail mid-transit, as do many private services. Given that fact, is a voter's selection truly final when he or she puts it in the mailbox? The majority doesn't want to answer this question, dodging it, offering the passing suggestion that Mississippi's law would be preempted only insofar as it allows voters to recall their ballots. May the Fifth Circuit hold as much on remand? Must state law expressly prohibit voters from using recall? Do the Postal Services or FedEx mail recall policies violate the Election Day statutes as applies to absentee ballots? You cast it, it's postmarked, you call it back, you send it again. For state legislatures trying to understand this, the decision now opens up Pandora's box. And finally, rants Alito, today's decision also leaves open opportunities for voter fraud that may further undermine Americans' faith in the integrity of our elections. Diverse sources have recognized that mail-in ballots increase the potential for fraud. Everybody. In June 2005, a committee chaired by Jimmy Carter and former Secretary of State James Baker found that absentee voting was the largest source of potential voter fraud in American elections. The Commission on Federal Election Reform, Building Confidence in U.S. Elections, cited that. Similarly, in Crawford versus Marion, 2008, Justice Stevens on the Supreme Court said that the risk of voter fraud perpetrated using absentee ballots is real and could affect the outcome of a close election. Some amici who are friends of the court in that case also explained that when voter fraud occurred these days, it generally takes the form of organized fraud, like using fraud ballots or mail-in ballots to get them in. Now, it's not difficult to understand why, says Alito. When someone votes by mail, it is harder for officials to verify the identity of that person who completed the ballot. Mail voting also presents a greater opportunity for voter manipulation, a more vulnerable chain of ballot custody, and a diminished ability to detect improprieties. And so today's decision compounds all of these vulnerabilities, allowing ballots to pour in the days and weeks after Election Day, by which point preliminary elections returns are already being publicly reported, creates even a greater opportunity for fraud and risks that undermines our elections. Kavanaugh has also explained when thousands of absentee ballots flow in after Election Day and potentially flip the results, charges of a rigged election can explode. And it's not difficult to foresee the types of fraught situations that the counting of late mail-in ballots may lead to. Suppose the outcome in a close presidential election hangs on the final vote in a state that allows officials to count mail-in ballots received up to 2 days before its electors must meet. And suppose that when all the ballots cast in person are counted by the morning after the election, one of the candidates is ahead by 15,000 votes. Now, as the mail-in ballots are arriving and being counted, suddenly that lead dwindles, like with Spencer. By Thanksgiving, the lead of the candidate who has been ahead since Election Day is now down to 1,500 votes. This figure holds until a few days before the state's electors need to vote, when one last tranche of mail-in votes puts the opposing ahead, and he wins by 87 votes, like Joe Biden. It is not pleasant to imagine what this course of events would mean for popular faith in the integrity of our elections. Even in the absence of partisan rhetoric, drawn out ballot counting induces a large and significant decrease in our trust. By allowing states to continue to get new ballots during these processes, today's decision will only exacerbate all of this distrust. Now, in response to this, Amy, she says the appearance of fraud could persist under our interpretation as well as hers. But that is non-responsive. It's as non-responsive as it is unremarkable. Ooh. No statutory scheme will eliminate concerns about fraud entirely, and nobody claims that an election day ballot receipt deadline would do that. But as the majority acknowledges, timing laws are one tool that the government has to reduce opportunities from fraud. And by the way, this whole fact pattern, he says, is very similar to Lyndon Johnson. How the Senate campaign that propelled his political career was marred by late arriving ballots that flipped the outcome when LBJ was running for Senate. In 1948, Johnson eked out a razor-thin victory over his primary opponent in a runoff. Johnson's victory was made possible through the election-flipping addition of 202 votes after the polls had closed. 200 of those late arriving votes were cast for Johnson. He won the race by 87 votes. In the decades since, weighty evidence has come to light, casting serious doubts on those votes' legitimacy. You're kidding. Although a complete account of what occurred is lost to history, the incident illustrates a real risk. So no scheme will absolutely eliminate all fraud, but you acknowledge that timing is important, and concerns about fraud were a leading cause of these rules. So it's undeniable that a prohibition on counting late arriving ballots would provide an additional hurdle for bad actors to stuff the ballots when early election results are tight. The majority incorrectly removes this safeguard. And so Alito closes out. Today's decision is inconsistent with the terms of election day laws, contemporary principles, 2 centuries of practice, and the case law that has come before us. It opens up and fails to resolve a host of questions for state officials and courts, and it creates a serious risk of further undermining public confidence in our elections and our system of self-government. So I therefore respectfully dissent. From Judge Samuel Alito in the dissent, and that's another loss for us. 5 days. Other states will come out here. They'll make it 7 days. Other states will do what Washington is 12 days. And the ballot harvesters and the fraudsters will continue to ultimately pack and stuff the numbers after the election is already over. So as we saw, thank you, Coney Barrett, for joining with the leftists. Thank you, John Roberts, for once again joining with the leftists. We've got a 6-3 court, but the libs win another one. And Alito's interpretation is very interesting, right? Amy is treating each voter as an individual and not really thinking about the election as a whole. But Alito is saying it is the electorate that is making its voice heard by election day, bringing some finality to the conversation, which I think is the much better approach. I think we really should have very limited mail-in ballots for people who are disabled, people who are mobile impaired, senior citizens, not for the mass convenience of some of the most uninterested people in the world. Like, if you don't want to get off your butt and go in and vote, then stay home. That's great. Maybe you're not an active participant in self-governance. Maybe you don't care about it. We want a little friction so that the good votes come in, not the fraudulent votes. And that helps to ensure the integrity of the election because you're there in person, much less likely to commit fraud using somebody else's ID or even just showing up and casting a ballot in somebody else's name. We've got all of these mail-in ballots, all of these envelopes that have to be opened and signature scanned and moved from location to location, move it from here, over here, over here. And the chain of custodies are completely perverted. They're all being shoved into the machines that nobody can count, nobody can verify or validate. And that's why faith in our elections continues to diminish. Meanwhile, our Congress is useless. They're not going to come fix this. And the libs win again, thanks to Roberts and Coney Barrett. So very disappointing on that one. We'll keep our eye on it. I would expect a bunch of other states, unless Congress does something about it, to follow this, because it gives the people who are running the elections and the harvesters of the ballots tools to win, even when they lose, as we saw with LBJ. So another bummer of a decision, 5-4 from the Supreme Court. Elections in perpetuity for all time. Thank you, Supreme Court. We'll see what the fallout is on this one. Thanks for joining and subscribing as we do. All right, we got one more decision, my friends. And then we'll hear from you. And let's see how long this baby is. We might just want to hit the syllabus on this thing. Who's doing the dissent? Yeah, this one's pretty interesting, actually. All right. So, yeah, let's hit this one. All right, this is going to be an interesting one. Very interesting decision out of the Supreme Court. We talk about geofences and the digital encirclements that permeate our society. We're all on our cell phones all the time, and they can track that. Where are you going? Where are you coming from? And is that data that's being gobbled up by the cell phone providers, all of the ad monitors, you check your Facebook when you're on your phone, Facebook knows where you are. Can that be accessed by the government without any Fourth Amendment protections? Or does the Fourth Amendment and the right to privacy prevent them from doing that? We have a curious split here on this one. It looks like we have not an ideological split. It's a 6-3. And we've got Judge Kagan writing the majority on this, joined by John Roberts, also Sotomayor, Kavanaugh, Jackson, also with Gorsuch concurring in the judgment, which gives us the 6. So concurring in the judgment, Gorsuch probably articulating a different rationale. Then we've got Alito in the dissent, Thomas and Barrett, which makes up the 3. So it's kind of like a 5-1-3, but splitting it in this manner because Gorsuch is agreeing and concurring in the judgment, but writing a separate opinion about these geofences. And so let's see what Kagan said. In recent years, law enforcement gets geo warrants. They can get your cell phone location data. And she asks a hypo. Suppose that investigators know a crime was committed at a particular place and time, but they don't have a suspect. So they may draw a geofence, which is a virtual perimeter around the crime, and get a warrant asking the company to hand over the data about the cell phones located in that area at the time of the crime. Following a process specified in the warrant, the company will then turn over a cell phone data and eventually identify by name one or more of the people that were there. Here, this is what happened. There was a geofence warrant at issue, was directed to Google and used to solve a bank robbery. Hundreds of millions of Google users have activated a service called Location History, which records the location of a cell phone every 2 minutes. Through a geofence warrant, which is a broad warrant, officers required Google to turn over the location history of cell phones that were in the area of the robbery. At the end of the process in the warrant, Google gave 3 names. The government soon charged one of those people here, this person called Okello Chatrie. Now today, we ask how the Fourth Amendment applies to that geofence warrant. Answering that question in full would mean we got to ask, was that a search when they acquired the data? And if so, whether that search was reasonable given the feature of the warrant that they employed. Now, we decide the first part of that today. Is this a search that implicates the Fourth Amendment? If it's not a search, then we're not searching you. It's not Fourth Amendment. So we decide that today, concluding the police did conduct the search when they got that data. An individual has a reasonable expectation of privacy and records about location, and when police intrude on that, which is a constitutionally protected interest, even if it's limited, even if it's coming from a third party, it is a search. Now, we leave to the Court of Appeals whether, given the warrant that was issued, the search here was reasonable, meaning that each of its steps was properly described with particularity, and whether it was supported by probable cause. It is a search. You do have to get a warrant. Is this one valid? We'll see. Now, modern cell phones, we observed a dozen years ago, are a major part of life. Americans are glued to their phone, as she details here. And among that information that the cell phone beams out is user location, ride-sharing apps, weather apps, fast food, Google, fitness apps. Everything's tracking everything. And with Google, it can get in within 20 meters of where you're at. Google prompts users to enable this. 500 million users have done that. They've got Google Assistant and more. They uses all of this data, routes it all back through their cloud services. And in the last decade, people don't know this is happening, but it can be obtained through a GeoFrence warrant. Such a warrant seeks information about the location, and put simply, it's to find out where someone was and whether they could have done this. And the mechanism is to use the cell phone as an identifying device. Now, there's some uncertainty about how often the technique actually works. Google got its first GeoFrence warrant in 2016. 2 years later, 11,000 of them have now been handed out. All of it is essentially the same. Tell us through location data who was there when a crime happened. So as this began to proliferate, Google worked with law enforcement to develop a three-step framework. One, Google produces anonymized with no names data within the GeoFrence. These are all the people that were there. It's a circle with a radius. That data includes each coordinate and timestamp. This is where this device was at this time, but no names. The data at this stage shows a location about every 2 minutes or so. Then at the second step, officials review the data and typically ask Google to give us information about a subset. New data is usually for a longer time frame. Then the third step is identities. So the GeoFrence warrant is designed to eventually produce a select number of people. So you take a big group, give it to cops. Okay, this is what we want. Okay, give that group, give it to cops. Okay, that's cause. Now we want this. So give us the names. On May 20th at 4:50, a man robbed a credit union in Virginia. The robber presented the teller with a handwritten note. He said, "Give me $100,000 or I'm going to hurt you and your family." Says, "My boys are on the lookout outside." When the teller said, "I don't have access to 100 G's, he brandished a firearm. He ordered everyone in the bank to the ground, forced the manager to open a safe and put almost 200 G's into the bag and left. Local officers responded, began the investigation, did interviews, surveillance, and could not find anything. Robber was at large, like that movie with Keanu Reeves on the beach. On June 14th, the police officers thus applied to a Virginia magistrate with a GeoFrence warrant to Google. The application said, "We want Google to identify data." They explained in the warrant that it could identify the robber and that he was likely to be there. So GeoFrence was actually big, was a circle with a radius of 150 meters, all surrounding the credit union. The warrant went on to describe the three-step process. One, we're going to get anonymous data from 420 to 520. Then at step 2, we'll narrow that down. Then at step 3, we'll actually try to get additional information about travel time and more. So still anonymized in step 2, which would expand the scope. And then at step 3, again, attempt to narrow down the list by comparing this information about travel time against the known time and location specific to this crime. So Google would then turn over the information for each user on the final list, including name and phone number at the end. Magistrate issued the warrant. Officers executed it. At the first stage of the process, Google gave up data for 19 users. Second stage, the officers winnowed it down to 19 to 9. Then Google produced anonymized data showing movements both inside and outside the GeoFrence for 2 hours, and then narrowed it down again. Google responded again, identifying this. One of the 3 people that they came up with was Chatrie. Location data showed that he entered the GeoFenced area about 10 minutes before the robbery and headed towards a residential area, then left the bank. Following this, grand jury charged him with robbery. He moved to suppress the information that the police had obtained. He said, "It's a Fourth Amendment search," and the warrant was invalid. Lower court mainly agreed with him, but still denied the motion to exclude the location data. Even though this particular warrant plainly violates the rights enshrined in the Fourth Amendment, the court said, the officer's reliance on it was not objectively unreasonable. And because that was so, the court concluded there's a good faith exception to the exclusionary rule that allows it to come in. Divided Court of Appeals affirmed. They held that the court did not conduct a search and therefore did not even need a warrant. That was so the majority reason because he did not have a reasonable expectation in privacy into his location data. So no warrant was necessary at all. Then affirmed. We granted cert only to answer that question. Is this a search? 2 questions. Did law enforcement conduct a search when they got his data? We hold they did, because you do have a legitimate expectation of privacy in your cell phone location data. And second, did the multi-step GeoFrence here make that search reasonable? We leave that question for down below. The Court of Appeals can address that, but we'll address only the search. So, pretty narrow. Fourth Amendment does protect the right of the people to be secure in their homes, in their persons, papers, and effects against unreasonable searches and seizures. The basic purpose is to safeguard privacy and the security of individuals against arbitrary invasions by government officials. The purpose is central to decisions about whether the Fourth Amendment search has occurred. Bunch of Fourth Amendment case law here. And what is an expectation of privacy? We have explained it is to secure privacies of life. We don't want arbitrary power coming in. We've had lots of questions about technology. And what about mechanical interpretations of the Fourth Amendment? One decision, we rejected a mechanical interpretation to hold that the use of a thermal imager to detect heat coming from a person's home was a search in the constitutional sense. Yeah, this is where in Kelo versus US, where the police were driving around with a image camera, like a, what are they called? Infrared heat image camera. And somebody was growing, I think, marijuana or something in their roof of their house. And they could like see it with the imager. And like, oh, that guy's got a grow house in there. Rated him. He said, no, that was a search. They said, yeah, it was. And in another, we held that the search of a cell phone incident to arrest could not proceed without a warrant. And so they're going to walk us through a bunch of case law. In this case, it's about historical cell phone records, CSLI records, timestamp records. Wireless carriers store a bunch of metadata about you. Walks us through the analysis on that one. And so the resemblances here leap off the page. Cell phone metadata is the same as location data. And location data is even more sensitive. So if that's a search there, then it's a search here. Really comparing and contrasting. Here, location information is different. No doubt, Google itself uses these records to improve apps, but they use this to track you. So the government, not contesting much of this, says that accessing only a short amount of cell phone location information does not count as a Fourth Amendment search. It's just a little bit. And again, the dissent also says it's about duration. Alito saying, no, it's just a limited, ping. And in deciding this case, this court reserved that issue down for the lower circuit. The government now claims the answer is yes. The 2 hours worth is here. There's a constitution-free zone because it's just a short search. But we're not going to believe that. So Kagan continues, short-term location that reveals private matters are all searches. We've never understood this only to kick in once a search goes too far. And so what creates concerns is that the government can access all of a user's movements and create a panopticon, which is to scrutinize a citizen's activities. And as in other cases, like a cop putting a beeper into a car to track somebody, the court said the beeper did not turn the tail into a search, but was explicit that its holding was only limited to that rudimentary technology. And so I think we get the gist of this. Let's see how far her decision goes. A lot of prior case law, Fourth Amendment cases are litigated all the time. Could go on for 1,000 pages. But a modern cell phone, pretty much everything a person does on a cell phone requires an opt-in. So even if you opt into this thing, everything requires an opt-in. So the dissent is probably saying, well, you agreed to opt into this and make it accessible. And it doesn't matter, she says, we hold that officers invade cell phones users reasonable expectation of privacy when they access location history. Doesn't matter if it was only 2 hours. Doesn't matter if it was handed over by a tech company. When the government accesses it, that's enough. Location history, as much as CSLI info, it conducts a search under the Fourth Amendment. But that conclusion doesn't resolve this case. Now they have to validate the warrant. So when officers get a warrant, it's got to be a reasonable warrant, probable cause, particularity. Here, this warrant was uncommon. It was multi-step. The first step laid out step 1, then step 2 and step 3, as we've talked about. So we leave all of these questions to the lower court. Was it valid or was it not? And ultimately, Kagan and the others vacate the judgment of the Court of Appeals, send it back down. This was, in fact, a search. Fourth Amendment does apply. And now you get to hold and validate whether the warrant was sufficient under this type of search. So Jackson and Sotomayor are agreeing. I would have gone further to say this violated the Fourth Amendment, so it shouldn't be used. She says she actually would go into the second question and say it was invalid. There was no judicial check. They got all of the movements. There wasn't enough specificity in step 2. Gorsuch concurs. He agrees. He said we have to look at Katz and other cases, or he's actually saying Katz might be a problem. So we have to remedy the Katz case. Count me unpersuaded. Why does trafficking this movement digitally over an hour or two invade his expectation of privacy when an officer tailing him from the same length of time would not? He's saying, okay, so this other case is a problem. Why is location history voluntarily shared, not truly shared, when a person's bank records are? So we've got some prior inconsistent Fourth Amendment cases that we need to rectify. And thanks to Katz's prominence, litigants sometimes fail to press more traditional Fourth Amendment arguments. But he hasn't forfeited that here. Set aside whether this data is among his papers and effects. I would say at least is one of his effects under the Fourth Amendment. Qualifies as personal property. That's his data, almost like a diary or a map of his movements. And so he would also say it is a search. And then we get to the dissents, which are down here, which will be Alito. He said, I've been warning about this. In 2018, in the Carpenter case, we need to clarify this, or we're going to have new revolutionary developments in new Fourth Amendment protected interests. The majority does this in an advisory opinion. Although today's decision will send seismic waves throughout our Fourth Amendment doctrine, not one iota of the majority opinion will affect the outcome of the case. The court knows this because they'll go back down and they'll just say the warrant was valid. By refusing to review to the one question that could have theoretically given him some hope of relief, Alito says he's going to lose anyways, the court set the stage for its planned performance, striking a pose as a great champion of privacy in a charade. So we shouldn't have even granted this. It should now either dismiss this petition or affirm the decision below on a good faith exception basis. Instead, this is an advisory decision that's not actually changing anything about a now obsolete GeoFrence procedure, which I guess maybe they're not using. Last term, the court worried out loud about rushing in judgment about new technology. And it's long been established that we cannot issue advisory opinions. His stake in this case stems from his conviction for robbing a bank. He argued that the lower court made a mistake in denying the motion to suppress the location data. So unless he can show that this evidence should be suppressed, he cannot obtain relief. And his chances of making a showing are virtually zero. They got this information pursuant to a warrant. When the evidence is obtained according to a warrant, he's got to seek suppression. And on the score today, the decision fails. The majority does not dispute the good faith analysis this is not casting doubt on the lower holding. All you're doing is just saying, yeah, we think it's a search too. This outcome was guaranteed as soon as we accepted this. When seeking review in this court, he recognized that dislodging the judgment required that he prevail on a good faith issue. So he asked us to rule on that, but we didn't. So the whole reason he came to us was to ask about, first of all, it is a search, reverse the Court of Appeals and say it's not good faith, and so give us a win. And they didn't do that. They only took like half the argument. So we shouldn't have granted cert. We should now dismiss this. This was all improvidently granted. We're weighing in on matters that we shouldn't be weighing in on. And so that's ultimately what Alito has to say here. And a lot of the Fourth Amendment is now changing. But ultimately, in short, under traditional principles, he could not challenge this under the 14th Amendment. We're now expanding this. We're now expanding reasonable expectation of privacy into all these technological areas. Yeah, and visual observations. These are all Fourth Amendment cases, so you can get into the weeds on that. But in this case, the GeoFrence procedure did not violate his Fourth Amendment rights. These precedents hold that a defendant does not have an expectation of privacy in records that a company generates because he uses them. It's called the third-party doctrine. We've already articulated it. In this case called Miller, the police did not violate Fourth Amendment rights when they got transaction records from his bank. He's giving those up. He's voluntarily conveying this information to the third party. That means he does not want them to be private. Same thing as here. He voluntarily gave it to Google. Google created the paper trail. Google is not a neutral custodian. They use this for all sorts of things. So it's not private at all. Once it leaves his hands, it is gone. So there's no support to say that it is, in fact, a search. He is not protected here. And ultimately, that's what Alito says. So he would say, you lose, you're going to jail anyways. You probably will anyways. I think that the lower courts will just say it was a search and that it was validly admitted anyways. But in sum, the majority argues that a duration-based or procedure by procedure approach would generate a host of line drawing questions. How long? How often? Whatever. I don't disagree, but those questions are inevitable. We're going to be answering those anyways. But in any way, your approach creates your own line drawing problems. What dividing line is a reasonable expectation of cell phone locations, but not bank records? So we've got all these different versions of papers and effects. How do you cut between them? Do you need a warrant for Amazon purchase? Do you need a warrant for search history, Venmo transactions? What else? Like, what else is going to be gobbled up here is what Alito is saying. So all this is going to do is create a big mess. We're going to be cleaning up debris for the foreseeable future. And Barrett also saying, I have no quarrel with Carpenter, but I agree with Alito that under the Fourth Amendment, including Carpenter, he had no reasonable expectation of privacy in data about his public movements that he voluntarily disclosed to Google. So I therefore respectfully dissent. So yeah, interesting split here. So ultimately, what did we say this one was? 6-3, but kind of like a 5-1-3. And yeah, Fourth Amendment law is very convoluted. It's all riddled with factual interpretations. This one was this because of that, and this one's that because of this. And a lot of the time they seem logically inconsistent. In general, I'm more in favor of making the police go get warrants. Like, just default. It's simple. Just make it the default. It's a search. You want to go get it, go get a warrant. Not complicated to do. I've got a lot of firsthand experience on this. They can get warrants very, very easily. And so just to be ultra sure that we're complying with the Constitution and not creating this compounding effect of getting access to things that may or may not be private. We don't really know until the court fleshes it out under each specific basis. Just go get a warrant. The judges hand them off anyways. Here, have a warrant. Here, have a warrant. You can make stuff up if you're the FISA court. A fake warrant, they give it to you. So I think that check is reasonable. And a lot of our data, I mean, on our cell phones, it is the most personal thing about us. It's all of our texts, it's all of our photos, it's all of our locations. And so we're in favor of more warrants, not less. It's easy. These judges, they're not doing a lot useful, so they can sit there and just sign off on the warrants. And in many cases, I'm not kidding you, it takes 20 to 30 minutes. Fax it over, hop on the phone. Sign the warrant, fax it back, you're done. And then you're covered. Constitution is covered. We at least have a little bit of a check in the process, and we don't have to worry about Chris Wray's FBI or Merrick Garland's DOJ, because it becomes a big problem, especially when they are spying on senators and House representatives. You think they give a crap about us? So ultimately, we'll see if this gets dismissed at the lower court. I don't think so. I think they just said it's a search. It's going to go back down. They're going to say, oh, okay, great, it's a search. But there's a justification for getting the warrant and evidence is admissible. So this guy's probably going to jail anyways, but at least they got a warrant. So we'll keep our eye on this one. Chatrie versus the United States. A little bit of a mixed and mingled holding, and we'll see what happens when it goes back down. All right, my friends, what a beautiful day it has been. If you're just getting here, we had 4 decisions drop today. We've got 4 more coming tomorrow, very likely, and we'll close out the Supreme Court term. Today was a mixed bag, I will say. We had a 6-3 decision in favor of the president's ability to fire Slaughter from the FTC. So the independent agency exception is largely dead, except if you're the Federal Reserve. The Federal Reserve came down, and 5-4, they said, but the Federal Reserve is special because of a tradition in America, which is the same argument that the left had in the Slaughter case. So 1 win, 1 lose on that. Then we've got elections in perpetuity in Watson versus RNC, 5-4. We got Amy Coney Barrett and John Roberts joining in with the left. And election day doesn't really mean election day. It kind of means election whatever. You want to get your ballots in 5 days after the fact, that's fine. Mississippi has now implemented that law. They win, and it will, I'm sure, spread around like wildfire to a bunch of other states because it's a great way to steal elections. So we saw that. Then we had a 4th Amendment case, which I think I agree with the holding ultimately. I'm in favor of more warrants, not less warrants. Let's have some checks and balances on the executive, on the law enforcement, prosecutors, police, FBI, DOJ, all these people. Just go get a warrant. Easy to do it. You know it's easy to do it. It's not even complicated. It takes you 15 minutes. So just go get it. Ultimately, I think that our digital life in many ways is more personal than even your personal life based on how technology is going. So I'm okay with that. So, but it was also kind of a weird split decision, Gorsuch concurring in judgment. And ultimately, 4th Amendment gets some backing with Alito and others in the dissent. But now, my friends, it is time to hear from you. And let's see what you say about all of this, man. It was a burner of a morning. And we'll come back tomorrow as well. So if you want to join us, 10 a.m., we'll have 4 more Supreme Court decisions tomorrow. Presumably, I'm expecting all 4, which means we're going to get birthright citizenship. Not positive about that, but they could presumably split it, do and come back on Wednesday, but we're probably going to get all 3 tomorrow. So we'll see. Friends, thank you for being here. Thank you for the donos and for all the love. I see some great comments in. Here's meme of the day. How I imagined evil as a kid. Like Satan flying around the depths of hell. Yeah, it's pretty true. How it actually looks today. Fauci, Gates, Soros, and the World Economic Forum guy. Yeah. Which all kind of have an uncanny resemblance to Satan. So yeah, it's not far off. Thank you for that. Hey, what's going on over here? Man, it's July 4th week, baby. America's birthday. Hell yeah. Hey, Michael Anderson. What's up, Michael? Thank you for being a membo and joining us up on YouTube. We're very appreciative of you. Thank you for doing that. So tomorrow is the last day. So forget what I said. Tomorrow's it. 4 decisions coming tomorrow. Trans case, election case, and birthright case. I'm ready to be disappointed. I'm ready. Let's just do it. Mr. Zancap, what's going on? 33 months as a member, man. Thank you, Mr. Zancap, in the house. Good morning, watchers. Good morning, Mr. Zancap. Great to have you here. Rob, we need to do like they do. Just keep counting. Yeah, I think that's right. I mean, the rules change. You can't just sit and kind of whine and moan about the old rules. I wish it was like this. No, it's that. Those are the rules. You got to play the game better than they do. So I agree. Rob, we're going to lose the House. That ends the Save America Act, and the Democrats will waste time trying to impeach Trump and everyone else. I'm getting sick. We're going to keep an air of positivity out there that we're going to win everything, baby. But if they do win, your point is well taken. That's 100%. They're going to go bananas. Voice, hey, next few days here will be bad. Heat advisory warnings. It's going to feel like 110 today. Due to the humidity, and I'm already soaked in sweat. It's true. They say July 4th is going to be like a heat dome in DC, which stinks. But Voice, thanks for the heads up, my man. Thanks for being a membo. Thanks for the comment today. Dora Joe Lewis. What's up, Dora Joe? Thank you, Dora, for being here and for becoming a new membo. We had a great Saturday stream this weekend. Hey, Debbie, SCOTUS declined to hear Trump's appeal of the Carroll verdict, courtesy of SCOTUS Wire. Did they? Was a decision made on that? That was like interesting. Thank you, Debbie O, for the heads up on that. Yeah, that was in a conference for like months. Wasn't that one? Was in conference for months. So they decided on that. Thank you, Debbie O. Interesting. Rob, there's no statutory requirement for SCOTUS to release the decision number birthright citizenship this year. We may not get it. It's true. They could bump it. They could hold it and continue it in the next term if they wanted to. I don't think they will. I think they're going to drop it. So, Rob, it's like you're in what are like the early stages of grief, like, you know, denial, bargaining. You're like, I think you're in bargaining right now. Well, no, I mean, they could just hold on to it for next term. Man, I hope they give us the right decision. Maybe these crap Federal Reserve decisions will give us a good birthright. You know, hey, Severus, Mountain Man and in finance. I don't track who is on the board. I disagree with the decision today. Hey, man, thank you, Severus, for clarifying that. Yeah, do like all the finance bros like know who all these board of governors are? I don't think so. Nobody ever talks about them. I can't believe they made that decision. What decision? Nobody even knows what they're doing. Do whatever they want and then apparently lie on their mortgages. Thank you, Severus, Mountain Man. Good to see you. How many miles was it? 55-mile man. Good to see you, Severus. Chris Creative. Amy's the worst. They played politics because she's a woman to get her confirmed instead of picking a good constitutional judge. It is frustrating. It's her and Roberts. And Roberts is... And they're inconsistent. I mean, I think Roberts today was like inconsistent completely. He's like, the dissent in slaughter is out of their mind. They're relying on a history and tradition argument. Turns right around the same day and releases a history and tradition argument for the Federal Reserve. It's like, all right, man. You're just making it up as you go along? Like, what's your deal? Thank you, Chris. Yeah, you know, we're going to hold our fire until tomorrow. We'll see where they come down on birthright. Hey, New Brunswick, the 59th Street. I'd buy that mug, Robert. Invaded and inflated. Yeah, that's not bad. It's a pretty good line. Invaded and inflated. It's true, man. It's been happening to us our whole life. Invaded and inflated. Yeah. Thank you, New Brunswick, for calling that out. Now I just got to make some mugs. Thank you, New Brunswick, for the donation. Hey, Dark Severiant in the house. Bringing in 5 new membos. We got Steve Briggs, Waltho Wallace Wesley. We got Gordon Novo, New York. We got Cajun Lass, CPS Scott, all in the house, courtesy of Dark Severiant. joining us as new membos. Man, great to see everybody. Natalie Ray, hey, what's up? Honorable Clarence Thomas is my spirit animal. He's the man. Yeah, he's like, Federal Reserve is unconstitutional. It's illegal. Kavanaugh, on one hand, is like, I'm scared. I don't know what to do. If we get rid of it, it's going to be a global collapse. Clarence Thomas, it says, it's unconstitutional. Burn it. Get rid of it. Gosh, man. That's what we appreciate. That's the type of SCOTUS governance that we need. Massive girth and length from Clarence Thomas versus Kavanaugh. Lame. Natalie, thank you. 14 months as a membo. Dark, what's up? 3 months, 90 days. Hey, made it to my first sub trimester. Amazing, Dark. 2 months to go, man. We'll have full baby in the house. There's Trump kissing the American flag. What a beautiful thing. Dark, thank you for being here. Thanks for being here 3 months. First month's the hardest. It gets easier from there. Hey, Sandy, what's up? Couple of donos. Nevada Supreme Court ruled the state must count mail-in ballots without postmarks. Oh, great job, Amy. That's what I'm saying. Thank you, Sandy, for that one. I'm going to have to get that one to back that up. We went through a lot of it, but I don't remember what cases specifically. Yeah, you don't even have to postmark it. It's a ballot. What are they going to do? Disenfranchise you? They're going to look at, oh, sorry, it's not postmarked. Oh, it's a voter. Oh, we have to count it. Oh, well, I have 10,000 more. Oh, okay, guess we got to count all of them then. Must be just an innocent mistake or a flub at the post office. Sure, bring it in. Sandy, Trump can change how postmarks get administered to stop fraudulent marking. Technology can also put a tracker or unique code. Yeah, but then they'll just sue him. And they'll stop the Postal Service from making any changes. Watch. And she hung her whole hat on that, on postmark. Even though, like, we pulled up a study, I think from the Postal Service, that a huge portion of things are not postmarked. Just statistically. A lot of stuff comes through that just doesn't get hit. And they just move it. Thank you, Sandy. I'll have to look that one up. Hey, Just Be Honest. What's up, Just Be? Thank you for becoming a membo and joining us. We'll get back to our members-only streams later in the week, but we got SCOTUS business tomorrow. Cliff, Rob, it would seem the Roberts Court would find it easy to say no to the challenge of birthright citizenship. Since this is taking more time, are they having difficulty with the phrase under the jurisdiction thereof? Gorsuch noted the 1922 when it required congressional action to make Native American citizens because they were under the jurisdiction of their respective tribes. Do we need a law for every country? I look for Roberts to punt to the Congress to fix this. Thoughts? Yeah, I think... It's hard to see. I thought that the oral arguments were not all that good for our side. And I'm trying to think of a key bit of that. But I remember listening to it. I think we listened to it here. And they just weren't buying in broad terms. Subject to the jurisdiction thereof, right, is really the phrase. There's two things that I think that they can hang their hats on. Subject to the jurisdiction thereof. What does that mean? Does that mean allegiance to the United States? Like you come into the country and you are subject to the jurisdiction thereof. You have subjected yourself. You have acquiesced. You say, I am allegiant to your rules and your law and your order. I will follow your rules. I will let you govern me because I'm subject to your jurisdiction. It's allegiance, really. Or is it you're just in the geography? Like you're in the jurisdiction of the United States. Like if you come in illegally, you're in the jurisdiction of the United States. You murder somebody, we're going to prosecute you and put you in jail. But you have not subjected yourself to the jurisdiction. You have not declared an allegiance or even indicated allegiance to the United States at all. So if they go with the former, we win. If they go with the latter, we lose. If it's just you're here, then we lose. The other component to this is the residency component. You read the rest of the 14th Amendment, in which they reside. What does that mean? And shouldn't that have effect? So if you're a birth tourist and you come in to have my baby in Miami and you drop a baby off, is that residency? Are you residing in America? No, you're not. So that word should have effect. So birth tourists should be gone. But then other people who are here even illegally, who are not allegiant to the United States. Maybe they do reside here. And so residency would give them birthright status if they have a baby. So I think there's another way to split that too. So, but it's a big one. Like, it's a big one. And I'm not sure that they have the cojones to undo it. First of all, I don't think it's undoing anything. I think that it is what it is. Subject to the jurisdiction and residency, those are requirements of allegiance and lawfulness in the country. Wong Kim Ark, in that case, where Wong Kim's parents were Chinese nationals, they came over, they had a baby, but they were lawful permanent residents. They were analogous to green card holders. You had permission to be here, so you have a baby, you're under our jurisdiction, you've acquiesced and been allegiant to it. We're going to give you the benefit of that lawfulness. So that should count. But whether they agree with that, we'll have to wait and see tomorrow. So we'll see. It's going to be a good one. Zone Girl, hey, great opportunity to say no unions in civil service and removal of lots of waste in government agencies, downsizing and consolidation of agencies. Yeah, and the SEC and FEC, and I think any independent agency that was siphoning off the unions or endorsed by the unions or interfacing with the unions are now under President Trump's control. So eat it. Thank you, Zone Girl. Hey, Sandy, Rob, the Federal Reserve case draws the distinction with the FTC due to the private business aspect, right? Yeah, except the Thomas dissent calls out the Federal Reserve Board. So like the Federal Reserve System, you got the banks are different than the board. The banks are different, like this, the private entities are separate than the agency, the Federal Reserve Board of Governors, which was created by Congress and does have some appointment and removal powers. That's not private. That's a government governance board. So think about that now relating to all of these Trump corporate joint ventures happening, or even the Venezuela partnership. In other words, you're saying those might have a component of legitimacy because there's kind of a government-private relationship. So like, you know, Trump IBM, right? America IBM. Yeah, and I don't know that the banking system is set up in that way with the government, but Clarence was talking mostly about the board and that the president should have the ability to fire the board and put his own people in there because that agency is set up basically as an independent agency. So, and again, I don't know what those, like how those deals are structured, but if there's an independent agency that's created to govern those things, those would live under the executive branch. Thank you, Sandy. Zone Girl, Roberts is so jealous of Thomas because he is revered, and we look at him with disdain because of his naivete and how we feel we should hold Boasberg accountable and censure him and his poor performance. Roberts is a weak head of the court, from Zone Girl. It feels like he's just trying, rather than being like a strong leader who just makes hard decisions and anchors himself in as a historic and iconic figure and Chief Justice, he's trying to just keep kind of both sides together and maintain a lot of the institutions, even if they're unconstitutional. Cliff, hey, recall, it is not beneath Roberts to legislate from the bench exactly what he did with Obamacare. He said it is unconstitutional to fine, but you can tax. So he crossed out fine, writes in tax. This should have been sent back to the House and the Senate and make politicians change the law, and more importantly, vote to tax the American people. When they then get to see how the next election works out for them, now Obamacare has failed and has wasted billions of dollars. Yeah, that's kind of my point about Roberts. He's like an institutionalist. So he, at that moment, did not want to undo Obama's key thing and found a way to thread the needle to make it fit, even though it's, what he's the judge, so he gets to say what is or is not constitutional, but it's a mandate that you go buy a product or else you get fined. You have to buy a thing from the government now. Like that's what America is now. You have to go buy a product or you're going to get in trouble. Okay. And that's conservative jurisprudence from Chief Justice John Roberts. I don't think so. Yeah, here you go. Hey, hopefully you are correct. The Federal Reserve is not federal, or there is or is there a reserve? It is a private banking cartel developed by J.P. Morgan and his friends in 1912, signed into law by one of the most destructive presidents in American history, Woodrow Crap Wilson. Great book on the topic by G. Edward Griffin. You know, it might be a good time to get him on the show, man. I have somebody who knows him. I'll work on that. The Creature from Jekyll Island, where they went down and just made the Federal Reserve out of their butts. Sassy, hey, I can't help myself. I feel like I must reveal this right now. Ready to send a robber to upload into YouTube Membo emojis before tomorrow. It's Clarence, baby. Supreme Justice Clarence. GOAT in the house, man. Thank you for that. Just Rhonda, a.k.a. Sassy Gemini, purveyor of fine emojis in the house. Sandy, yeah, we'll get that in. We'll get that in for tomorrow because he'll probably be the only one with any sense. Sandy, a common carrier is someone who delivers goods to a public, all the public, so long as they pay a fee. It must be indiscriminate. Ballot harvesters do not qualify as common carrier. UPS, FedEx, DHL, and others do. Yeah, I think at the moment in Mississippi, that's the rule. But during oral arguments and what we saw in, I think it was Alito's dissent that we just read, he asked the question, what if you change that? What if you say, like in Minnesota, you know, you can vouch for 8 other people? Well, if you can vouch for them in person, why can't you vouch for their ballots? So you just take their ballots and you just say, oh, I collected these on Friday. Okay, it's Tuesday. When did you get them? Friday. Oh, okay. And you just vouch for them and you collect them. Can a neighbor bring your ballot in? Can someone from your household bring other people's ballots in? What is the limiting principle? What is the limiting rule? So how do you prevent the fraud from getting injected into the system? If postmarks are not legit, are not unequivocal and infallible, and a state can really dictate how things are being collected, what if the state just says, yeah, you can just go have your neighbor bring them in, or a community organizer, or somebody who applies for status with the state, because not everybody has money for FedEx or DHL or UPS or whatever. And then do those have to be postmarked? What if can they just vouch for the number and just say on the honor system, I picked these up at this time? What are the limiting rules? That's why we want election day. That's why the electorate makes their decision on election day. Get them all in. Then we don't even have to ask about that. Don't need postmarks. Don't need any of the collection or the harvesting or the drop boxes. When did you drop it off? When did it get picked up? What if it comes in 1 day later? You think they're not counting those ballots? Come on. So Sandy, thank you for the question, and the clarity. Trump says a couple of posts. Let's see what Trump says. Thank you, Sandy, for flagging those. We'll go over there. Tony, hey, I think even Trump would admit he made a mistake with Amy. We'll see what he says. We'll pull up his tweets. You might be right about that. Hey, it's the Munkets. Tony, hey, Munkets in the house. Peng Wan, good to see you. 36 months as a member. Thanks for nothing, SCOTUS. I know, we had too much winning last week. They had to make us hurt today. Sandy, I'm not aligned with the Fourth Amendment dissent on this one. To say you voluntarily waive your right to Google is wrong. If you are waiving a right, it must be expressly and not implied. Nobody accepts product in return of waiving Fourth Amendment rights. Yeah, was it in Google's terms of service that you waive your constitutional rights to use the cell phone? I don't think so. I haven't read it. But I think it's what is reasonable? What is a reasonable expectation of privacy? I would say people's phones are like the most reasonable. People put everything on their phones. Their phone is everything. You ever like pick someone else's phone, like, don't touch that. All right, it's got everything. It's your whole life in there. So I think it's reasonable for us to have an expectation in that privacy, and using these services when everything is hyper integrated in order to use the service gives us that expectation. I have an expectation in it. Every time I send an email, yes, I'm using Google service, but they're affording me a modicum of privacy. that I think carries over to the other things. Like, would Alito be okay? Oh, Google just, yeah, there's no right to privacy in your emails, no right to privacy in your iMessages because they go through Apple servers. So I don't agree with that. And I think that the better procedural deployment of this issue is to have us have that privacy, more Fourth Amendment rights, not less, and the government can go get a warrant. They're looking for criminals, so it's worth it to them. They're not looking, they're not fishing for criminals. They're looking for somebody. Just go get a warrant. And again, it's easy. It's like super easy to do it. Ask any police officer. They'll tell you. They have plenty of evidence, especially in a bank robbery case like that. Like, yeah, judge, like, here you go. Go get him. Okay. And everybody's usually pretty happy about that. So then when the defendant comes back out, it actually makes a defense lawyer's job harder. Just go get a really good warrant, a really solid warrant. We have everything covered. Particularity, and we've got an articulable basis of probable cause. It's all there. Get the data. Then the defendant goes in. He goes, oh, crap, I'm totally screwed. Great. You did your job. Don't have to waste a bunch of time litigating all these issues, all of the fine lines in the Fourth Amendment, Venmo and Uber and PayPal and banking and, location. Just go get it. Then we'll all be happier for it. A neutral judge just gets it. And it's not complicated. So Natalie, hey, Rob, I saw this and thought of you learning what humidity feels like over in DC. It is hot. It is hot. Although it was beautiful this weekend, but when that humidity hits, it feels like a punch in the face, man. I'm from a dry heat. I'm still getting used to it. But we just deal with it because we love America so much. So when we go out, we just say, ain't nothing. This communist humidity has nothing on my love for the country. Sandy, ACB did hang her hat on the postmark, so doesn't that overrule Nevada? I don't think so. I think that she was hanging her hat on Mississippi's rule. And Mississippi's rule said postmark. The real crux of that case was about the deadline, not about the postmark. She brought it up a bunch, but I don't think, she was just saying the law says postmark by this. There was some time, and we kind of went through that one a little bit faster because it was very technical, but some hanging of the hat on the postmark as though it is before the election. But again, what if you just substituted that out? What if the state law said it was really about receipt of the ballots? And if the state sets the rule, this is what Alito was warning about. If the state sets the rule and the federal laws don't preempt that, it doesn't specifically negate what the state says, then according to her, the text is what the text is. And if Congress doesn't like that, Congress can change it. But she's not going to measure state law against federal law on issues that the federal law doesn't explicitly preempt. So what happens if they change that? What if they say also somebody can, a state certified voucher, a state certified collection person can collect the ballots. Just go apply, you can collect ballots. And you then turn the ballots in and the person validates it's postmarked. Or what if they don't say it's even postmarked? Just get your mail in. California, apparently you can just get them in. They go by your signature. What if a state just says any mail-in ballot that was signed before the election? That's it. It comes in, good to go. What would Amy say about that? It doesn't conflict with federal law. It doesn't say anything about signing it or postmarks. It's all about the collection deadline, which was the crux of that case. So I think Alito is right on that. I think that they're going to exploit that massively. And why wouldn't they? But maybe there's something in there that we fast forwarded through on that, Sandy. So I think Nevada can still stand. They can just say, yeah, it's state law. This is what it is. And we govern time, place, and manner of elections. And federal law says election day. But election day really means you got to make your choice by election day. That's where the timing comes in. Your choice is made by election day, but the mechanism, the manner of that choice, Amy, in this case, the mechanism of choice by the timing of election day was the postmark. But what if it's just a signature? What if it's a person collecting the ballot? I think that all of those would probably, according to her rule, also be sufficient. So we'll see. All right, let's take a look and see what else we got cooking over here on the channel. We're live, man. It's been a burner. We got a couple of comments. Let's see what Trump is saying as well over on Truth. Okay, Trump is dropping some burners here. Big win just moments ago at the Supreme Court in the slaughter case, confirming presidential power in our country to remove executive branch officers and agency appointees or representatives under Article 2. The decision was long sought after by United States presidents dating all the way back to the 1930s. It is such an honor to be the sitting president who won this historic and unprecedented ruling, one of the most important ever given with respect to presidential powers. Thank you for your attention to this matter, Donald J. Trump, the president. And he just read Gorsuch's concurrence. Gorsuch was like, look what you've done. You're giving all this power that Congress delegated to an independent middle of the road branch right back to the president. So maybe the court should correct that. Maybe Congress should correct that, but they won't. Trump is right. That was a huge win. I mean, that was a really, really big win because all those agencies are now essentially his. Now, he also shared this one. He confirms, in light of the tremendous loss in the Supreme Court today about voters' rights and the fact that people's votes, people's in quotes, are allowed to be counted long after an election is over, it is more important than ever to pass the Save America Act, which is all voters must show ID. Even that they don't want. All voters must show proof of citizenship. No mail-in ballots except for illness, disability, military, or travel. Couldn't agree more. There is no excuse for a politician or otherwise to be against the above three requirements. There is only one reason to oppose: cheating. The House has approved this vital act 3 times. The United States Senate seems unable to do so. In a time when there is a powerful communist movement taking place in our country, one more dangerous than World War I, World War II, Pearl Harbor, September 11th, all Democrats, and our 5 Republican Senate holdouts, Lisa Murkowski, Susan Collins, Tom Tillis, Bill Cassidy, and Mitch McConnell, who may or may not even be alive, must vote to save our country. There can be no more excuses. Thank you for your attention to this matter, President Donald J. Trump. He's right about that. And John Thune doesn't want to push people to do it. We have the votes over there. Hard for us. Donald Trump also said, surprisingly, the Supreme Court declined to review a fake case brought against me by a woman I never met. Decades-old celebrity line photo standing with her husband does not count. I will continue the fight against this weaponization and lawfare case against me, including the ridiculous claim of defamation, with all my power and strength. This case is really against the United States of America and all it stands for, and should never be allowed to happen to another president or candidate to be. New York State created a law for an instant speck of time going back many decades in order to wrongfully nab me in a civil lawsuit. It was tailor-made, and this injustice cannot be allowed to stand. Thank you for your attention to this matter. Your favorite president, Donald J. Trump. And I think we got one more from him. And here is what he's, maybe 2 more. The Cook lawsuit having to do with her suitability and sitting on the board of the Federal Reserve was sent back by the Supreme Court on a strictly procedural basis. We will take appropriate action immediately to make sure that someone who has committed wrongdoing will not be making vital decisions concerning the welfare of the United States of America. Thank you for your attention to this matter. Signed by the president, Donald J. Trump. And I think one more. Let's see if he had another one. Yeah, to show the importance of the slaughter case, 90 years of precedent has been completely and unequivocally overruled, greatly increasing presidential power at a time when it is most needed. President Donald J. Trump. Nice. Yeah, it's a big one. It really is a big one. And I'm sure his team right now is just salivating, dripping with salivation. for all of the good stuff that they can do with this new decision. Very good stuff. All right, so let's see what else we've got. We've got a couple of comments that came in. Hey, Michelle, Rob, if SCOTUS overrules the Title IX type cases tomorrow, then the Supreme Court would be denying science, thus delegitimizing them, plus denying every woman of their legitimate rights. Yeah, I feel pretty good about those. Amy Coney Barrett is not into the trans stuff. That's my prediction. She is not into the trans stuff. And there was that one decision where I think a trans was trying to say that they were subject to like intermediate scrutiny. We've got these bases of scrutiny. And, you know, women and men can be treated differently under the law. They're not the same. And the best example of that is like a birth certificate. Like if a baby comes out of a woman, that's the mom. Put the mom on the birth certificate. It's pretty clear because of the vagina. In it separately, men are not. So, you know, paternity rules can be a little different than a mom's maternity rules because it is different. Men and women are actually different. So the law can treat them differently. There's this thing called intermediate scrutiny. And there was one decision that we read, I forget what it was, but Amy Coney Barrett was like, you're not intermediate scrutiny, not even close to intermediate scrutiny, not even in the ballpark of it. So don't ask again. Like she was not happy about it. So I think that she'll at least be on board. We'll see what the others do. But I can't imagine Kavanaugh is a big proponent of dudes on women's sports. So I agree. I think both of those are going to go our way. We'll have to see. But you're right. I mean, you're right about that. Now, you know, we had, it was a much different court, but we had Obergefell and these other cases. And I don't know that society is like at the same place with the T's as it was with the G's when we got that case. Acosta Labs, man, thank you, Acosta Labs, for the dono. Amazing to have you here. And another one from Michelle. They would be denying science and women of their legitimate rights. Okay, so we got a double paste there, man. Thank you, Michelle, for the dono. Yeah, I think both those will go our way. I think the campaign limit cap predictions, campaign limit cap will be unconstitutional. So they'll want more money flowing into politics. So both T cases, I think, go our way. The election spending cap probably goes away so that more money can go out there. And the birthright case is going to go our way. I hope. Really hoping. So we'll see what happens tomorrow. Of course, we'll come back at 10 a.m. to get into it again. Neuro D, what's happening here? We've got, hey, that's us, Neuro D, sharing watchingthewatchers.locals.com, our members only community. You can also join us on YouTube as well. Normally we do member streams at this time in the morning, but it's SCOTUS season, so we've been here. CR Citizen says the reside reference in the 14th Amendment makes citizenship exclusively federal and infers that aliens are not residents of any state and not constituents of any public office. Residency does not confer citizenship. Only naturalization does. Yeah, that's right. And I wasn't saying that being a resident makes you a citizen, but I'm saying that if you, so like in Wong Kim Ark, they were lawful residents and the Supreme Court found that their child was a citizen. And the basis for that, I believe, was because big, long decision, lots of dicta in that one, but they were here lawfully. They were subject to the jurisdiction thereof. Even though they were not citizens, they could pass citizenship to their child because they were here acquiescing to the laws. But yeah, being a resident alone does not convey citizenship. No question. Adele, the Republicans are doing it all wrong, playing by the rules, hoping the bloody SCOTUS will make the right decision. It is time to go on the offense and cheat our way through every election. Let's cheat bigger than them. That might be, I mean, I don't want to cheat. I don't want the Democrats to cheat. I want some actual reform so nobody can cheat. That's what I want. But ultimately, if there is cheating happening, the only way to beat a cheater oftentimes is to out-cheat them. You have to, like, whatever the rules of the game are, they exploit those. You got to exploit them even harder. Adele, Federal Reserve Cook, this decision is the result of Roberts protecting the globalist every step of the way. Weird exception. for the bank. We hate independent agencies. They're all illegal, except the Federal Reserve. We love them, though. They're amazing. Hey, CR, what's up? Allegiance, Citizenship, and Oath, sharing a couple of Substacks over there. Securing the election process, a framework as well. God is with us in the house. And yeah, these are pretty true. Oh, no. Ketanji got the Leering Center placard. Kavanaugh conservative until he isn't. We got Uniparty Roberts. We got conservative Alito. We got badass MFer over there, Thomas, no doubt. Uniparty Barrett, DEI Sotomayor, liberal Kagan, and the Leering Center. It's great. All right, so friends, it has been a beautiful day. And yeah, a lot that we covered today. I think we'll probably pause here for the afternoon and then kind of save up our voice and our energies for tomorrow morning. And we'll have another burner tomorrow. We've been in a cold civil war our whole lives, says Winning Reality. Yeah. And it's like a soft secessionary environment. You've got literal sanctuary cities that are an open violation of federal law. If you send in federal troops to go in there, then they wage an insurrection against you. It's like kind of resembling a battle in America between Americans in the fashion of a civil war. So it's not good. But all right, so friends, I think we'll pause here. Let me double check. We got some locals comments. And then we'll see if there's any other really good reactions out there. And then I think we'll pause on the day and then come on back tomorrow morning. We'll have another burner stream because we're going to have some big ones that are out there tomorrow dropping. Here's one from Zone Girl with a prayer. Dear Heavenly Father, let SCOTUS rule the right way. Implore you to lead SCOTUS to rule that election day is one day. We didn't get that one. And Lord, guide these men and women with judicial wisdom and common sense and keep them safe from the threats and harm. Fill them with calm, resolve, and bravery to render tough decisions. Lord, protect them and their families. Bless our nation and open our eyes to your truth. Amen. Amazing, Zone Girl. What a great prayer. Yeah. So everything was pretty good. For whatever reason, Jesus said no to election day. He said, no, I'm not giving you that one. Okay, Jesus, we love you. Your wisdom, you know better than we do. Okay. But the other ones were good. So Zone Girl, very good prayer. And birthright citizenship is still out there. So maybe Jesus can help us on that one. We love you, Jesus. Really good prayer, though. Thank you, Zone Girl. We do. You know, our judges, and to be honest, like we have some bad decisions, but we have a much better Supreme Court than we've had in a very long time, a really very long time. So we're happy about that. Hey, Rick D, saw an interesting story about cell phones and personal fitness devices. The company that processes flock cameras wants to expand their ability to monitor cell phone and personal wearable fitness devices in public areas. Wild. Yeah, so, you know, is that a search? Is that something to which you have a reasonable expectation of privacy? You're in public, so maybe not. But your cell phone, like every time it's pinging off things, it's got, you know, it's transacting data. It's kissing the other end. So Patriot Alpha, hey, not a lawyer, but who thinks SCOTUS ruled in favor of the Federal Reserve to protect the power of the Supreme Court? Yeah, 4 branches of government. Got it. Yeah, the Federal Reserve, it's just like, it's this Goliath. It's this undefeatable monster. It's the creature from Jekyll Island that nobody can ever beat, even though it's got no home in America's constitutional order, as Thomas said. Dan, historical information about mail-in ballots, 24, 22, and more. The outlier was 2020 because of COVID, and that's the one they stole, very unequivocally. Thank you, Dan. And they changed the rules. Like they changed a bunch of rules. Judges stepped in and said, we have to change the rules because the governor issued an emergency. So the governors, the secretary of states, the judges on various courts all bypassed state legislatures and said, well, COVID, emergency order. Everybody sign these documents and we'll just change all of the election rules. Dan says, the reason for the 5 days were typically 5 business days when the county offices would be open to receive the ballots. 5 states hold elections on days other than Tuesday. So this is from somebody called the Daily Brew. Let us check out 4 states that all hold elections on Saturdays. Okay. Hawaii, Louisiana, South Carolina, Texas, and Tennessee all hold their elections on Saturdays for certain things. So for primaries, right? So these are all primaries. Yeah, these are all primaries. Municipal elections and other internal state things, but not federal elections, right? They're not holding federal elections on Saturdays. They're holding the election, but now they can count the ballots really in perpetuity for however long they want. So thank you, Dan, for those details. That came over from the Daily Brew. I feel like I've heard of that. Like a daily newsletter brewed with information. Good stuff. Yeah. So friends, tonight will be a good night to say some prayers and hope that what we get tomorrow is a good outcome for the future of America. SCOTUS will be out with 4 more decisions, and we're looking forward to those. And so we'll pause here for the day. We'll come back tomorrow. We'll be back at 10 a.m., 9:45 a.m., and we'll have birthright. We'll have 2 trans cases. We'll have an election case, and that's going to close out the docket for us. So it's really an election spending case, how much money can be spent in federal elections. But it's been a beautiful stream. Thank you for joining us as we made our way through all of these decisions. One very good one, one good one in the 4th Amendment, and then 2 not so good ones. Now, the silver lining in the Lisa Cook case is she could still be fired later on once it goes back down and the facts are applied to the new standard. So that is not a good one, but may turn into a good one. The bad part of that is that they really propped up the Federal Reserve. And then the election day thing is just, I think, going to be exploited. And we'll see more of that happening throughout the rest of our lives until Congress actually does something. But it's been a beautiful stream. Thank you so much for joining us. We'll clip out each one of these into its own independent video and then get those published as well. But hopefully we see you back here tomorrow to get into it again. Want to thank our amazing mods and meme smiths who modded the fort down for us and keep things nice and orderly around here. K Bean in the house. Thank you, Muffin Rando. We got Carrie B. We got John, Donut Mind Me. We got Neuro D, Janek, Dog Digger, Geegum Geegum, Elliot, Just Rhonda, Purveyor of Fine Emojis. And thank you, Donut and K Bean, for keeping things nice and orderly around here. And friends, thanks once again for subscribing. Thanks for joining our channel. Thanks for being here, liking the video on the way out. We'll come back tomorrow. We'll get into it again. And in order to do that appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, a beautiful evening, sleep very well. Supreme Court Day tomorrow. We'll see you right back here then. Until then, be well and bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers shine in the light. Watching the watchers defending what's right. Watching the watchers stay